Ladies and gentlemen, Excellencies, good morning from Berlin, from the representation of the state of Bremen with the Federation. My name is Michael Windfuhr. I'm the Vice Director of the German Institute for Human Rights and the General Moderator for today's event, titled Safeguarding Rule of Law in Europe. Good morning also to Bremen, to Gdansk, Warsaw, Krakow, Brussels, Karlsruhe, Munich and Heidelberg, the places from where our speakers have been brought in by video. And good morning also to many other places in Germany, Poland and different countries in Europe and out of Europe. We're glad that way more than 600 persons have registered for this online conference, which is additionally transmitted in a live stream in 3 languages, which makes it possible for further persons to listen in. We're very glad that members of parliament from the national parliaments in Germany and Poland, as well as MPs from the European Parliament have registered, and we would like to welcome you very warmly too. We're pleased to have judges from highest and supreme courts from European countries, the Council of Europe, Central Asia, representatives of national ministries from EU member states, and the European Commission, representatives of national unions of judges and solicitors from European states, scientists from all over the world, media representatives, and many interested people interested in the rule of law in Poland, Germany, and other European states. So a warm welcome to all of you, and also to several representatives of various embassies in Germany and our European Network of National Human Rights Institutions, NRI. The event was conceived on the basis of joint intentions of the 2 national human rights institutions in Poland and Germany, the Polish Commission of Human Rights, Professor Dr. Adam Bodnar and his team, and the German Institute for Human Rights and its director, Professor Dr. Beate Rudolph and her team. We anyway cooperate as neighboring national human rights institutions regularly, and we'll have to do that. We thought that we want to organize basically on the eve of Germany taking on the presidency in the EU, organize an event that gives us and many experts the chance to think about how the rule of law in Europe can be strengthened and secured in the best possible way. We currently see that the foundations of the European Union are slightly jolted, and they're even challenged as a community of law and rights and values. It's based on the fact that all member states, individually and together, pay attention and adhere to the fundamental and human rights and preserve them. Independent courts are key to that. Who else would protect our rights when governments, parliaments, or administrations infringe on them? As long as all EU member states are states of law, this will work. Then and only then will there be justified trust that the courts of the other state made independent decisions, that is, without arbitrariness and in consideration of the human rights. For this reason, only states that are constitutional states and states of law can be and become members of the European Union. This is why we want that the Polish and German national human rights institutions strengthen the consciousness of people in Germany, Poland, and all over Europe of the importance of the independence of the judiciary. We want to show that the independence of the judiciary is under threat, and we want to make it clear what European standards are in place for the independence of the judiciary. And we want to ask how the European Union and its member states can secure the rule of law in Europe. We are very pleased that we could win over the federal state of Bremen as partner and venue. Bremen is the twin city of Gdansk, which is an important civil society bridge between the 2 countries. It's the contacts of the people, the diverse neighborhood, political, cultural, and also family contacts between the countries that contribute to a lively and lived Europe. Europe has its importance in the fact that people of the European countries are brought together, that nationalist demarcations are reduced, and that peaceful and intensively lived neighborhood is enabled. City twinning is therefore a great and very important instrument. We're all the more glad that we today have both mayors at this event and that they will open it with an input. The mayor of Bremen, Dr. Andreas Bovenschulte, and the mayor of Gdansk, Alexandra Maria Dulkiewicz. Also, we have been enormously pleased and moved by the fact that we have attracted so many proven experts to this event, starting from the Commission of Justice of the European Union to the judges of the Polish Supreme Court and the Federal Constitutional Court and other outstanding experts. Thanks so much that you all have taken the time to discuss the importance of independent judiciary today with us and what role it should play in Europe. At times of the pandemic, it is not so easy to develop event formats that allow us to come together in this diversity from so many countries and to open up spaces for discussion. Still, we cannot yet meet again physically in the same place, and this is why we thought up the current format. We have one true physical venue, the Bremen representation here in Berlin, and a few of the speakers and facilitators are also on site here. Most of them, however, will be brought in via video link. In one case also will give a video message, which was pre-recorded. At the same time, we have translation into 3 languages, German, Polish, English. We have never had such a format here, and we hope that technically everything will work out and that this format carries us and allows us an exchange. So be patient with us when on the way you have to wait for a few seconds until the next technical switching has been done in the background. It's important to mention that with Grażyna Baranowska on the Human Rights Center of the Poznan University that also supports our event overall, we have attracted a steward of the audience. As we have such a large audience, and I can't see you anyway, especially when one of you wants to ask questions, we have set up an extra communication channel, a chat. You can also send your questions in via mail through the live stream. You can ask questions there, give comments, and Mrs. Baranowska will see your questions and in the discussion rounds will systematize them and summarize them and present them to the panel. So we hope, despite the format and the size of the audience, we will be able to enable your participation as the listening audience. The event will be co-opened by my colleague Maciej Taborowski, the Vice Commissioner of the Republic of Poland for Human Rights. Dr. Taborowski studied in Warsaw, Regensburg, and Oxford as a Doctor of Law and has a professorship for European Law at the University of Warsaw and also at the Institute for Law of the Polish Academy of Sciences. Maciej, over to you.
Ja, die von mir beschriebenen technischen Probleme sind schon jetzt aufgetreten.
Well, the technical issues I described beforehand have already arisen. We need just a few minutes of time in order to arrange the sound of the presentation of Mr. Taborowski. Maybe you just have a few seconds of patience, and we hope to be able to proceed just in a second.
So, dann nochmal. Jetzt soll es klappen.
As it seems, we are able to proceed. Now I would like to hand over to Mr. Maciej Baborowski, who is the Vice Ombudsman in Poland for Human Rights and Civil Rights. Matthew, the word is over to you. Good morning, and many thanks for the introduction. I hope that you will be able to hear me. Ladies and gentlemen, I would like to warmly welcome you on behalf of the Ombudsman of the Republic of Poland for Civil and Human Rights, Dr. Adam Bodnar, for the Ombudsman, and for ourselves who are members and staff of the office. It is a very special event. It is a kind of a summary of the 5-year term that is about to wind up in 3 months of time. And it is a very nice opportunity to summarize our fight for the rule of law in our country. After 30 years, after the wall came down and the fall of the communism, we see the need in my country to fight for the rule of law and the judiciary in my country. And this is the case because in the framework of the reform of the judiciary, we have seen certain infringements of the judiciary, changes of roles and positions of certain institutions, and the Constitutional Court of the country and the Supreme Court are bound to changes. And the big majority of the country has seen a certain occupation of the courts that is secured by the government, and we have seen a limitation of the independence of these institutions, a sad consequence of disciplinary proceedings against judges and allegations against the adjudications and rulings of the judges, where the European law is applied according to the European Court of Justice. We can safely see that this reform is not obedient and expedient to the optimization of the courts and the acceleration of proceedings. We can see this fact in the Constitutional Court. We see a residing trust in the institutions from the people, and of course, we see less proceedings submitted to the Constitutional Court, which is quite an unfortunate development. The people have lately seen that during the pandemic we have looked for solutions that were basically against the civil rights. And this, of course, as a consequence, has led to a weakening of the interactions with the European Union. The EU Commission has launched 4 different proceedings against Poland because of infringements and failures that have been committed. All we have to ask ourselves the question is how long we are going to proceed like that. The judges have asked several questions. They would like to know if the newly appointed judges, among them the members of the 2 new chambers of the Supreme Court that basically make up the half of the judges in it all, and those decisions will have a special impact on the newly appointed president of the Supreme Court. And with that arises the next question of how the Polish government is to handle the final decisions of the European Court of Justice. Are they willing to bound by those decisions, or are they rather eager to take on their own path in order to erode the system? The Ombudsman's opinion is that for the best of the people and the citizens of the EU, we have to defend the rights and the values of the EU. It is rather important to find a consensus in different fields of action, but we may not cross the red lines where the law is breached and the liberties and freedoms of people are at risk. And on behalf of the Ombudsman, I would like to invite you to talk and discuss about the red lines, the borders of the rule of law and the judiciary in our country, and of course about our freedoms and our future. Thank you so much. Well, many thanks, Dr. Taborowski. We will now proceed with the event with two already announced inputs. The two mayors here present, and I am really glad and pleased to be able to welcome the mayor of Bremen, Dr. Bovenscholte, who is one of our hosts. He is the mayor of Bremen since 2019, and at the same time a senator for the cultural affairs. He is a social democrat and has a doctorate in law.
Mr. Windfuhr, Mr. Borowski, very many thanks for these friendly introductory words. And thanks for this invitation to this conference. Unfortunately, the sound is extremely bad, and the interpreters can only hear part of it. Sorry for that. So, a very warm welcome to the co-organizers and everyone in the audience of this event. Specifically, I would like to welcome Mrs. Dulkiewicz from our twin city in Gdansk. Very prominent audience and participation in today's conference, which shows the importance of securing the rule of law in Europe. Objectively, I can only share that view of our organizers. Sorry, the sound is too bad for interpretation now.
Über Demokratie, die kann ein bisschen besser oder ein bisschen schlechter sein. Letztlich darüber zu reden, wie man den Rechtsstaat sichern kann, da hätten die meisten Menschen mit den Schultern gezuckt und gesagt, das ist kein besonders interessantes Thema, weil das ist ja gewährleistet. Und ich glaube, in vielen Bereichen Europas wäre die Reaktion die gleiche gewesen. Doch gerade in den letzten Jahren zeigt sich, wie fragil dieser Zustand ist und wie zerbrechlich.
Okay, we try again. Over the past years, it has become evident how fragile this situation is. Societies are drifting apart economically, socially, and also in a social way, and at a central state level we are still far away from a shared European idea, farther than this had been evident in the past few years. Sorry, we have to discontinue again. Sorry for that.
Ja, erneut.
Well, again, the technical issues have not yet been quite resolved. We have sound issues in the transmission from Bremen to this place. So this is why we are now trying to have Mrs. Dulkiewicz, the mayor of Gdansk. We would like to invite her, and in the meantime, we would like to improve the link to Bremen so that we ask you for your patience. I had said that this is a format new to us, so may we ask you for patience. So Alexandra Maria Dulkiewicz, the mayor of Gdansk, she has been in office since 2019. She's also a lawyer, and she follows to Pavel Adamovich in the office, who was the victim of an assassination in 1992. Since 2010, she's on the city council of Gdansk, and for the electors group, everyone for Gdansk was elected. So we're pleased to have you. Over to you.
Dzień dobry Państwu. Witam serdecznie.
Good morning to all of you. I warmly welcome you to this event, I am greeting you from the city of freedom and solidarity, from Gdansk, and I would like to especially welcome Mayor Andreas Bovenschulter from our twin city. We hold the historically longest city twinning. We will celebrate 45 years of an anniversary of this twin city-ship, and all the more I would like to invite you to this celebration. Ladies and gentlemen, just a short overview from the perspective of the City Council here in Gdansk. And as introduced, I am a lawyer. I'm a lecturer for law, but being a member of the City Council and being the mayor of Gdansk, one of my tasks, of course, is to protect the law the best possible. And when I took over the office, I was laying an oath, which is not only presented by members of the City Council, but other members of the public administration, but not all think about it. And what concerns our conference, the rule of law in Europe. Poland, fortunately, thanks to the consequent coherence and policies of the EU, and I feel a lot of gratitude for the striking people of the shipyards. We will celebrate 30 years of Solidarność when the agreement of the striking party of the shipyard workers were signed. Those workers of the shipyard, as part of our country, have become full members of the European Union 2004. But from the perspective of Poland now, from 2020, what the situation is currently and the rule of law. We can see here proven lawyers in the audience and among the speakers. And for me, we really need an assessment if the rule of law is still existing in our country. So this is a situation we are facing just right before the elections that were supposed to take place on the 10th of May. And all the other mayors that are following up and that are appointed according to the regulations and that draw up the electorates, the lists of the electorate. We have received an anonymous mail that said that the lists of the electorate have been given out by the PIS, which is a state-owned enterprise. And this is a moment where many of us, or the majority of us, more than 2,500 constituencies and mayors have backed the law to defend the right of the people in order to protect the privacy of their data and for them to be able to participate in the elections. And then the provision of those electorate lists would be a breach of law. We have backed up the law in that case. So the collaboration of many kinds of different the Judiciary, the executive, and the legislative bodies have a key role, and I hope that we will not having to face the situation ever again. I would like to warmly welcome you again and wish you a fruitful discussion throughout the day. Thank you very much.
Ganz herzlichen Dank, Frau.
Thank you so much, Ms. Dulkiewicz, for your input. Let me ask now, is the transmission okay now between this place and Bremen? Yes, it seems so. So let me announce once more. Our host, Dr. Bovenschulter, the mayor of Bremen since 2019, he has been in office, and we're very pleased that you can provide us with your input now. Over to you. Hello, can you hear me? Unfortunately, the sound does not seem to have improved. Trying once more to remedy the issue. Just a moment, please.
Ja, Herr Dr. Bovenschulte.
Dr. Bovenschulte, now our third attempt. You're the mayor of the state of Bremen, in office since 2019. We're pleased to have you as the host of today's event. Well, we have had some delays. Can you hear me now? Can I be heard? Sound is bad. So I would suggest that you continue. Let's continue. Then we won't lose any time. I think there are so many important voices that I can just say I'm pleased to join you and hope we don't have any more technical issues. Thank you so much for understanding that. I do hope we can resolve that. Let's continue. We have broken down the event in two content-related panels, two discussions. The first will focus on the importance of independent judiciary for the state of law, and the second, we will talk about the rule of law in Europe. How can it be best secured? The first panel discussion will be moderated by Armin von Dr. Doctor and Director of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, one of the most important international lawyers of the latest generation, 2008, for his outstanding scientific achievements in the field of basics of law and economy. He was awarded the prize of the Berlin-Brandenburg Academy of Sciences. This part of the event, however, is opened with two keynote presentations, and we would like to begin with Professor Dr. Małgorzata Gersdorf, a former president of the Polish Supreme Court, and Dr. Ulrich Majdowski, justice at the German Constitutional Court. First, we will play a video of Professor Dr. Gersdorf. Between 2014 and April 2020, she was the president of the Polish Supreme Court. She was against restructuring of the judiciary by the PiS in 2018. She was pensioned off but refused to go into pension in April 2020. Her office ended, and in 2019 she received the Theodor Heuss Award. We will now listen to her video message.
Dzień dobry Państwu. Przede wszystkim chciałabym bardzo...
Good morning, ladies and gentlemen. I would like to very warmly thank you, first of all, for the honor to be invited to this conference. I would like to ask a theoretical question. What can be said about a country where such things happen, like dismantling of the prosecutors, of the constitutional courts, and of the regular judiciary. Furthermore, the carrying out of disciplinary proceedings against justice, and that according to the will of the Minister of Justice, who is also the general prosecutor in the country at the same time, and the dismantling of the Supreme Court, where a court is working inside the court, a court before the court, namely the Disciplinary Division of the Supreme Court. When we look back to what has been achieved in the European Union, to the theory and philosophy of law, we will discover that a state of law has the following fundamental features: equal treatment of all citizens and regular jurisprudence by independent courts. And this is a fundamental feature scientists of the democratic world point out. A state that is based on an individual prerogative is sanctioning the principle of independence, of non-involvement of the central place by legal regulations which serve the purpose that at the personal request of the highest people, punishments are imposed and proceedings are initiated. That is a state where the dignity of individuals is trampled on by, for example, these people are treated infamously without having been given a sentence, and only by the media and hate speech these people are hit. Such a state cannot guarantee its citizens' security. The state uses fear rather than the law, which is very sad. Unfortunately, today's Republic of Poland, a member of the European Union, is like that. Even not quite so, but it is following this route. We know that the independence of the courts and their legislative constitution are characterizing the courts in a democratic rule of law in Europe. I would like to describe a few mechanisms to underpin what I have said, which have an impact on the courts in Poland and which allow it to the government to influence the course of proceedings in courts. First of all, staffing of the courts with judges. The eyes of the mythic goddess of Themis are covered. And this can be interpreted in two ways. On the one hand, as the prohibition to influence those who conduct proceedings, and also the necessity of being unbiased. At the beginning of the Right and Justice Party, its boss, Kaczynski, secured that for him effective work and the independence of the courts are very important. Of course, he introduced something very different. Instead of the alphabetic assignment of cases to courts, he introduced drawing of lots by a computer to assign cases to the courts. So this algorithm is on a basis that has never been disclosed. There is a saying that if certain mechanisms are introduced by people, they can also influence by people. But this is not all. There are courts to whom this mechanism doesn't apply. It's the Constitutional Court and the Disciplinary Division of the Supreme Court, namely very important panels of the judiciary. This is the first critical point. The second critical point is the administration of the courts. The Minister of Justice, who, like I said, is at the same time the general prosecutor, had 6 months' time in order to exchange the presidents of the law. And this is what he did. 120 presidents of courts were exchanged against others in this short time of period, irrespective of their ability and professional background they have. They were just exchanged, replaced. And it's not the case that it doesn't matter at all who's the president of a court, because a court president has a major influence on where a judge is active in what division. The president can put a civil judge into the criminal department, or, what is perhaps the worst punishment for a judge, he can place a criminal court to the family law department. And someone who has been familiar with criminal matters is a very good lawyer and suddenly has to deal with family matters, with childcare. It can as well happen that the transfer of such a judge means that he is deprived of his cases, especially in criminal matters. So all this needs to be reopened, which means a statute barring is imminent. So a president of a court, that's a very important person in organizing justice. And such a court president is under the influence of the powerful Minister of Justice. The third critical point concerns the system of promotion and appointment of judges. Today, these exclusively depend on the State Council of Justice, KRS. We call it Neo Council of Justice because the State Council of Justice is unconstitutional. It has been appointed through and by political bodies, and this council is not what our Constitution refers to. So all appointments of judges on the motion of this council are not correct, in our view, at least. My fourth point, disciplinary matters. Disciplinary matters depend a lot on the Minister of Justice, that is, on the general prosecutor. The disciplinary proceedings against judges are heard before the disciplinary division of the Supreme Court that has been set up by the Neo State Council for Justice. This says everything. That means the division of disciplinary matters can change the contents of a sentence. The rights of the defendant are smaller than a person that is being sued for killing. So what is the most important thing? In what I have already said, I dealt with what has taken place, but it's continuing. What is most important is the disregard for the judgments of the European Court of Justice. Even punishments are imposed because of application of these courts' sentences. In 2019, the European Court of Justice, in response to a prejudicial question filed by the judges of the Chamber for Labor and Social Matters, the answer was that the judges should themselves judge the Polish judges to see whether the judges appointed by that council are independent. In the answer, there were also several pieces of information as to what the judges should pay attention to. The judges at the regular courts and the Supreme Court, represented by 3 judges of the Division for Labor Matters at the Supreme Court, hence pass a sentence or a judgment on the basis of the European Court of Justice. And because of that approach, disciplinary proceedings were instigated against these judges, which were, however, argued by several and different reasons. And newly appointed divisions of the Supreme Court, in disregard of the judgment of these 3 judges, passed their judgment without that, even though this judgment was excellent. So, upon the motion of the first chair of the Supreme Court, a joint decision was passed by 3 chambers of the Supreme Court, according to which, in brief, the disciplinary division of the Supreme Court is not a court. So this decision was made on the 23rd of January of 2020. The European Court of Justice in April, on the 8th of April, suspended the activity of the disciplinary division. The judgment of the European Court of Justice applied to all state organs, so also for the first president of the Supreme Court. Thereby, the first president of the Supreme Court ruled that the disciplinary division must not pass any judgments anymore. Unfortunately, this ruling immediately after the period of office of the first president of the Supreme Court ended, was changed, namely by Zaradkiewicz, a judge who was temporary first president of the Supreme Court. He was to start a general meeting of the judges in order to appoint the new first president. This was not within his competence. He was not allowed to do that. Irrespective of this judgment, the disciplinary division continues to pass judgments against prosecutors, solicitors, and it also passes judgments about the removal of the immunity of a judge, even though they say it's not a disciplinary matter, but this is wrong. The fifth point is most important. The role of the Constitutional Court in implementing the projects of the government, which pursues the goal of dismantling the independence of the court, including the Supreme Court. After the three divisions of the Supreme Court had passed judgments, the executive found that it was now the time to turn to the Constitutional Court, with the rationale that the Supreme Court has exceeded its jurisdiction with this judgment and has started to create new law. That means that the judgment of the three divisions is non-existent. Of course, the Constitutional Court, totally without any reasoning, accepted this concept of the minister-president, of the premier, and thereby exceeded its own jurisdiction, because it's not their task to pass judgments about judgments of the Supreme Court. So this court intervened with the jurisdiction of the Supreme Court. So we are today living in a system that has the features of authoritarianism with some elective possibilities. Elections do take place, but those in power have all competencies and all powers to decide all matters of the citizens. In the end of the day, I think that we will not disappoint Europe. We will remain a state of law, and the Polish judges are certainly aware of the obligations they have taken on. Our entire population has been involved in the meantime. It is being supported by the European states, and in the dark time of the war later on and also now. And I thank all Europeans for that, the European member states. Thank you for that. And I count on further support of our population. Thank you so much.
Herzlichen Dank müssen wir.
Many things we have to say. This has been pre-recorded for this event, for these very interesting times that we are running. As a next speaker, we may be able to welcome Mr. Dr. Ulrich Majakowski. Since 2014, he's a judge at the German Federal Constitutional Court. After having studied law in Tübingen, Aix-en-Provence, he was working as a judge at the Administrative Council in Aachen, and later at the Higher Court in North Rhine-Westphalia, and then being a judge at the German Federal Constitutional Court. I'm really delighted to have you here in order to talk about the independence of the German judiciary. Many things. I hope we won't have any technical issues now, and you will be able to hear me now. We have just listened to the statement from Ms. Gersdorf, and between realism and pessimism, and none of us it's exaggerated. Unfortunately, we have to say so. But nevertheless, let me try to enrich this picture with two more colors. I always need, and I guess we all need, despite everything, our idealism and just a little bit of optimism. However, the question that we have to answer remains the same. Who protects the independence of the judiciary if governments or national courts do not perform this task, if they even actively endanger the independence of the judiciary by invoking a problematic understanding of democracy? This question is part of the pan-European reality, but we are all affected by it. In such a situation, hope is not only directed at state institutions, but in a special way as well at the European courts. However, in the light of the current events, the question has also been raised as to whether the German Federal Constitutional Court, whom a member I am, has rendered the task of the courts, and in particular the European Court of Justice, as guardians of the independence of the judiciary, more difficult or even impossible through its PSPP decision of the 5th of May 2020. But before I take position on this question, I would like to make 4 brief remarks on the rule of law, which may seem all too easy to you, who are all experts, but which are very important to me, nevertheless. First comment. We are all subject to the rule of law. The rule of law does not only need the contribution of the judges, the public prosecutors, the authorities and the government, but especially the trust of the people and a feeling for constitutional values and fairness in the classical and social media. This includes the willingness to offer constructive criticism and to accept final decisions by the independent courts, even if they're considered wrong. And only in the interaction of all these contributions is when the rule of law is created. This means, however, that the protection of the rule of law cannot be achieved by one of the above-mentioned parties alone. We need all of them. The second comment, the rule of law tolerates diversity. Not in all the different countries of the EU or convention states. The rule of law does not have to be understood and practiced in the same way. Anyone who talks to colleagues around the world knows about it. And evermore, the same rule can work well in one model of the constitutional state, but be highly problematic in another. Who wants to protect the rule of law must maintain this flexibility and diversity. Third comment, the rule of law needs red lines. For despite all its diversity, the rule of law is not something arbitrary. There are basics which are guaranteed in every system and which must be essentially the same. These basics concern above all the central place or the central venue where the rule of law must prove itself, and that is the court, including, of course, the position and the status of the judges. If one of the most important substantive aspects of the rule of law is the need for independent control of sovereign power, then this is the red line that must never be crossed, despite all legitimate differences in the details. And especially, we have to be able to find a way to bind the rule of law against the judges. And fourth and last comment, judicial independence can not only be endangered from outside, but also from within. Of course, government and parliamentary majority, a one-sided media landscape, or loss of trust among the population are powerful factors in the dismantling of an independent judiciary. But the erosion of the judicial independence also takes place independently of these factors in the midst of the judiciary itself. And this happens in sometimes a spectacular manner and sometimes in an everyday manner. And I'm talking not only about judges who are deliberately infiltrated into the courts as compliant executors of an anti-justice policy, but I am also talking about colleagues who see judicial independence as a privilege and not as an obligation, who are arrogant towards the parties to the proceedings and who place procedural rules at the service of their own convenience. In other words, those who work unprofessionally. The protection of the judicial independence must also start here, through the anything but self-evident ability to criticize colleagues and even to accept criticism. An important aspect of this is the ongoing dialogue on judicial ethos. Let's now come to the decision of the 5th of May in 2020. The decision of the Federal Constitutional Court has been warmly welcomed by the Polish government. And many critics therefore accuse the court of having shown to the Eurosceptics, the populists, and the neo-nationalists an easy way and a comfortable way to ignore the European Court of Justice, citing the German example, and this at a very inappropriate time. I am totally convinced that this accusation is unjustified, and I would like to give you my reasons for this conviction, but 5 aspects are important to me. First of all, the strengthening of the European Court of Justice is one of the aims of the decision. Of course, one can either agree with the decision of the 5th of May in 2020 or view it critically. This applies to the statement of the Federal Constitutional Court on the European Central Bank, as well as those on the ECJ. However, my conviction that this decision does not support the position of the Polish government is completely independent of whether one joins the camp of the critics or that of the supporters. A close reading of the text, which, after all, is around 40,000 words long, will reveal that this ruling is not intended to weaken the ECG, but to strengthen it. But I see already that I have to explain that. The second aspect, the competence and the jurisdiction of the ECG are totally undisputed. This is not something that we dispute as the GFCC. An important part of the decision of the 5th of May states that the ECG obviously has exclusive competence to interpret union law in a binding manner. And this is not a lip service. This is not something we read from the textbooks, but it is a continuation of Honeywell and very seriously meant. With the PSPP decision, we are moving in the area of a very rare, extremely rare exception. And this alone shows that our decision must not be used to justify a detachment from the authority of the European Court of Justice at will, in a specific will, or even in general. Let's now come to the core allegation that we have raised. It might be quite surprising to hear that we see insufficient legal protection. In our understanding, the ECG based its decision on the PSPP on the facts as presented to the public by the ECB. I'm sorry, the sound is really bad. I'm not able to understand it. That the decision of the ECG is not part of this category. And the fourth aspect, strong words as a protection against unjustified criticism. How can we deal with it? Why is the PSPP decision so, let's put it like that, rudely formulated? Why do we write no longer comprehensively or objectively arbitrary? I may say that these are not really diplomatic formulations. Maybe we're really not that good at that. But those rude formulations protect the ECG from unjustified criticism. This might sound strange at first sight, but it is correct because we have a very high threshold of objective arbitrariness that must be accepted. Everything underneath the threshold that may be considered right or wrong has to be accepted. The example of Poland makes it quite clear, I think. What the ECG has stated in its decisions on the rule of law in Poland certainly does not reach this threshold. And this is why the Polish government may find wrong what they hear from the ECG, but it is bound by it, may they like it or not. The fifth aspect, just quite briefly, accusation of a deficient factual basis is considered typically German. Critics say we have a typically German understanding of procedural law, which may not be transposed to the European law as a whole. This is not something we take for granted. We assume that even according to the European understanding of fundamental rights, effective legal protection depends on the court not only issuing an expert opinion, but assessing the specific case. This also includes the precept of audiata et altera pars. It is not in keeping with the ethos of the judge to accept the assertions of a party on the facts without examining them. This can only be done if the procedural law allows to do so. So in the validity template under Article 267 of the TFEU, such an instrument is not pertained. And in order to work with solid facts basis, we need the rules of procedure. Let me now finish with an image. I think in the dialogue of the courts, there is no simple solution. The ECG, of course, is the one issuing binding rulings on the union laws, and the Constitutional Court is then finding the way to interpret the national law, the national constitutional law. But they look for a collaboration. Let's just imagine the ECG and the German Federal Constitutional Courts as two friends who undertake a walkabout. And here they find a very nice but a bit mythical building, the European House with many rooms that we've been talking about for such a long time. It's already a bit older and with many extensions. The two friends to explore this building. The ECG looks at the inside of the building and the GFCC at the outside. And this then leads to neither of them seeing the whole picture of the building. They cannot make a very appropriate and wholesome description of the image, which is only possible when they meet once and again during their exploration and exchange their impressions and findings, the way we do it today at this nice event. So thank you very much for your attention. Many thanks, Dr. Majdowski, for your input, not only for the imagery in the ending, the friendly walk that we entertain in the end, and as well for the explication and description on the ruling of May and what was at your heart when you formulated this ruling. Throughout the upcoming debate, you will be able to participate with answers and, of course, questions as well. So we will be part of the discussion in your position for the further debate. I would now like to welcome the moderator Armin von Bogdanny that I already introduced. Further participants is the judge Władimir Wróbel, who is the judge at the Polish Supreme Court, Dr. Angela Nussberger, the well-known expert for comparative law and international law. She has been a judge at the European Court for Human Rights. In 2020, she has been appointed one of the three international judges at the Constitutional Court in Bosnia and Herzegovina. And then she is an extraordinary member of the Venice Commission of the European Council, who are assessing the states of Eastern Europe in constitutional affairs. Grażyna Baranowska will be our representative of the audience. She is the perfect person for it because she is fluently speaking all three languages of the event. I would now like to hand over to Mr. Armin von Bogdanny, and I would like to hand over this debate due to a few technical issues. I would now like to ask you to take over the 10 minutes of break that we have presumed in order for those people having an online connection being able to get up and get a coffee themselves. So, Mr. von Bogdanny, I hand over to you.
Good morning, everybody. Welcome to this panel on the issue that there is no rule of law without an independent judiciary. As has just been mentioned, we now have two presentations, which to some extent will also be a reaction to what we have just heard. Then Judge Majdowski might come in as a reaction to these two presentations. And then we go into the discussion, and Dr. Baranowska will present the questions. We have time up to 11:50. I am informed that we need to finish precisely because politics are waiting. So without further ado, please, Judge Wróbel, give your input into our discussion. Thank you. The floor is yours.
Thank you very much, and thank you very much for the invitation in this very interesting, I hope, debate and discussion. I will start with only a few words, because I think that it's more important just to debate on these topics than just to present the fixed thesis. Professor Gersdorf, our former Chief Justice in Supreme Court, described the essence of the crisis we are dealing with in Poland. These symptoms are visible, I think, not only in Poland, but in many other countries, not just only European, I think. And this is the basic question for me. Are they specific to a given country, or are they a sign of a more general tendency we are facing? So personally, I am in favor of the second position. The source of the nowadays crisis must be traced to cultural and technological transformations of the last decades, especially regarding, I think, communication. They directly affect the crisis of many institutions and principles of the modern rule of law. It is enough to mention the threats of manipulation that we observe in the elections or votings in many different countries. Probably in brief, this crisis can be described as a new populism, I would call it, technological populism maybe, versus the traditional rule of law and liberal democracy. It seems that the attack on the independence of the judiciary cannot be analyzed in isolation from the roots of this basic crisis. So, asking the question was posed, what can we do or what should we not do in this situation? So, apart from describing the consecutive, more and more depressing symptoms of the crisis, so Professor Gersdorf didn't mention the new events in Poland with appointing of the new Chief Justice of the Supreme Court, also with the violation of the Constitution. So maybe it is worth to try to understand and analyze its causes, the roots of the crisis and the mechanism of its emergence. Perhaps it would require separate long scientific debates, but personally, I see these reasons, these roots in two perspectives. First of all, the attack on the independence of the judiciary and on judges, literally, is a characteristic attack that populism makes on institutional authority, on elites, on social group that can be cast as public enemy, caste, oligarchy, and concentrate negative social opinions around it. The need to fight such a group is an essential fuel for populism as a way of gaining power and maintaining power. Refuting authority brings emotional satisfaction. It is sensational. Judges, with their splendid isolation, silence, mysterious costumes, palace buildings, mysterious rights and language, are very suitable for this purpose. The populist revolution needs aristocracy that can be overthrown. High-earning lawyers are also great for emotional assault. Discreditation, that's what works. The work of lawyers seems unnecessary because it is only a complication of simple things settled according to the standard of common sense. And the common sense criterion is dictated from elsewhere, but continues pools and spin doctors. Second perspective, the attack on the independence of the courts has a more classic and prosaic reason as well. Populism wants to take control of those institutions that may limit its ambitions. Independent courts attached to the value of liberal democracy and the rule of law are a natural obstacle, especially constitutional courts or Supreme Courts. Under the slogan of a moral revolution, right-wing or left-wing, it really doesn't matter, a revolution of ordinary people by subordinating the courts to political power, populism, on the one hand, abolishes the control of law over the activities of the political executive or parliament. On the other hand, it provides another means of communications. They have, the populism itself, they could use the court rulings. Contemporary populism is realized primarily in the sphere of communication using modern technologies. Thanks to them, it is possible to ignite and manage emotions, negate knowledge and rationality, produce hate and fake news, manipulate people. And the essence of the court's activity is also communication. Judgments are messages. For modern populism, a communication tool such as courts is necessary. So I come back to the question, what can we do? What should we not do? First, the paradigm of thinking about the authority of the court must be changed. Get out of the wedge and mystery paradigm. Open up to contemporary culture. So, what to do? Change the language of communication. Change the way we justify our judgments. We should be active participants in public debate, where it takes place, also in social media. Legal decisions, our judgments, our verdicts must be able to be described in moral terms, conflicts of values understood by ordinary citizens. The application of the law cease to be legitimized solely by the fact that it was adopted by the competent authority. It is not enough today. Statements of courts must make contact with the contemporary culture, also popular culture, in the language and emotional rhetorical layer. The courts are to administer justice. The administration of justice is not only the normative content of the decision in the world of values. It is not always easy. It is this judgment, verdict, is also, and perhaps above all, a message about what is fair, what is just, what is good. The decision in the world of values. It is not always easy, I understand. Does any of us explain to someone who came to the court the axiological reason of our decision for rejecting his complaint because he didn't met the formal criteria? Does anyone, apart from a formal reference to the legal provision, explain what these formal conditions are for? Lack of time. Yeah? People will then listen to the lawyers if lawyers draw them into the world of values that citizens can recognize emotionally. Second, or third now, education. Court must be open. Judges must be present and recognizable in schools, in social organization, in educational activities at all levels. Visitors must scroll through the courts. The court's successes, the court's success, the real success, is the audience in the courtroom, not the empty rooms full with the lawyers. Because only then we have someone to talk to and explains the sense of the rule of law. Fourth, acknowledgement. So the first manifestation of the threat to the independence of the judiciary is the refusal of acknowledgement by the executive. The verdicts are not respected. The political power undermines their rationality. Public officer discredit the judges personally. Criminal or disciplinary liability or measure for the verdicts, for the judges, for what they are doing. Because the courts have no real power. Convention, rather, is the natural environment. Conventionality, legal meanings. We speak the words of judgments that matter and change the situation of citizens only if someone acknowledges it. As a rule, it is about the executive. If this acknowledgement is lacking, then regardless of all the legal finesse and arguments we use, our judgments will have no effect. But acknowledgement can also come from within the court system. The courts will respect the judgment of the other courts. If we understand this judicial system in a broad sense, then recognition can be based both in national and EU courts or in the courts of the other EU member states. This judicial acknowledgement is becoming a very, very important factor in defending the independence of the judiciary against populism. A kind of a bypass, maybe, substituting the lack of acknowledgement from the side of legislative or executive power. But this bypass cannot last long. That's another question. In connection with it, this paradigm of thinking about judicial cooperation in the area of the European Union must be changed as well. An examination of whether a court decision of another member state is a judgment of an independent and impartial court or judge cannot be purely formal now. Perhaps it would be worth creating an institutional mechanism inside the European judiciary for permanent assessment, screening of the state of independence of the courts and judiciary in given EU countries. Something like Venetian Commission, open for the other courts. This would be helpful in deciding on specific matters by very simple courts, somewhere in the small town in the provinces of Spain, Poland, or Germany. Second, we need to change the paradigm of thinking about time. Populism doesn't work according to clocks hung in the noble courtrooms. Speaking by the Court of Justice or the European Court of Human Rights on matters related to judicial review standards after years from the time the dispute arose is completely ineffective. It has no sense. It is like giving birthday wishes after the death of the birthday boy. Third, decision of the highest judicial authorities of EU countries relating to EU standards on judiciary, or maybe not only on judiciary, must take into account the perspective and significance of these judgments for the other member states. This is the case of the judgment of the General Constitutional Court. Perhaps it was not enough, or perhaps it would be enough. It was enough just to change a little bit the language. Maybe it was enough to add some reservations. Maybe it was enough just to add a fragment explaining the German specificity and the fact that it cannot be transferred to other countries or the entire Union. Maybe it would be enough and it would help a lot. And the sixth, lawyers. Populism is not able to subordinate independent institutions without the help of lawyers. It is unable to fill the courts with obedient employees without the help of lawyers. Without at least silence of lawyers, challenging the rule of law would be much more difficult. The paradigm of lawyer education and the legal profession must be changed. Much greater importance should be attached to the ethical principles of exercising these professions and sanctioning violation of these ethical principles. In this perspective, the activities of reliable judicial and prosecutors associations are very important. The Polish experience of previous years indicates the importance of the role of these associations in defending the independence of the judiciary. The profession of lawyers is a vocation. Do our students understand that? Every lawyer is ethically obliged to protect the value of the rule of law. The lawyer is not just a hired employee for good money for any purpose the client wishes. He can practice his profession only by promoting the rule of law. We should develop these ethical principles that should be followed by lawyers also in the time of crisis, of conflict with populism. And seventh, the last thing, caution. Where there has not been yet a crisis, or where there have been opportunities to return to the rule of law, it is now very necessary to introduce changes and reforms that will strengthen the functioning of institutions protecting the rule of law against populism. Tradition and legal culture is a beautiful thing, but against populism, it cannot replace real guarantees. Arguments like, I've heard it sometimes, in our case, in our country, the Minister of Justice would never take it seriously, would never take the steps against judiciary. It wouldn't be possible. After the experience of populism, the real populism, it only raises a smile of pity. Legal tradition implies a community of values. The power of legal tradition is also based on the common method of legal reasoning. When someone shows up who turns the table over, who denies these common values and begins to interpret the statutes according to other reasoning, legal tradition can no longer defend anything. That is why the reform must be started now, immediately, in this country who can do this still, as long as rational legal reasoning still has some effectiveness. Also in the area of lawmaking and social persuasion. And at the end, anecdote. Once we met young Austrian criminal law scholars. In Austria, there is a very old regulation of recidivism in criminal law. I'm dealing with criminal law, that's my profession at the university. So this regulation allows, based on a very general and unspecified premises, to deprive persons who have already served a sentence. Very traditional solution. We asked our Austrian colleagues if they were not afraid of these provisions, that this provision could be abused somehow, especially by populist politicians in power. They told us that it would not happen because the Constitution forbids it. To our question, what would happen if such abuses still will happen? They answered that this is the pure theory because the Constitutional Constitutional Court would forbid it. You know, their imagination was beyond their reach. But it is the lack of caution. Thank you very much.
Thank you very much for this highly stimulating presentation, which gives us wonderful amount of great topics to discuss. But before we do that, we come to Angelika Nussberger, and I'm sure that she will give as a flamboyant introduction as we just heard. So please, Angelika, the floor is yours.
Thank you so much, Arnim. I'm the fourth in a line of speakers, and I'm very happy to be here and to be able to comment. And I just want to make three remarks on President Gerstov's speech, three remarks on Judge Majdowski's speech, and then three more general remarks. And I will try to weave in some thoughts as a response to this really excellent presentation by my Polish colleague, Judge Wróbel. So first, just to take up what President Gerstov said, I think her insights is extremely valuable for us to understand because she's a voice from within. And there I want also to position us. We are the neighbors, we are the outsiders. And the first thing we have to do is to listen to what our Polish colleagues tell us and explain us about what is happening. And that is what I want to stress about Mrs. Gerstov's speech. She shows us a split society and also a split community of judges. And that makes us very thoughtful. We see that politics is divided. And but I still want to stress that for us as outsiders, as bystanders, we have just to accept that there was the majority voting for a system which adopted, if I am informed correctly, within 2 years, 13 new laws on the judiciary or concerning the judiciary. So that is what we see, what we have to what we observe, and there is what's coming in, what Judge Wróbel explained, that civil society, as I understand, lawyers and actors, they have to be active from within to change, and I think change can only come from within. My third remark to what President Gerstov has said, she used very, very hard words. I have read the translation of her speech. I was not able to follow it technically now, but I think that it was the same text. In this translation that I have read, she used the word dictatorship and she used the word authoritarian. And just to add a very hard statement, in one of the opinions of the Venice Commission, it stated that what is happening in Poland is literally worse than what happened in the Soviet Union. So these are very hard and strong words, and I want to put them into context to what Judge Wróbel just explained, because I think it's not specific. It's true. It's a general movement, and it's probably not helpful to look back to the past, but it's a new challenge. And the challenge for us all is mainly that our model of rule of law, which we thought is so well accepted that you just cannot be against it, that this is not accepted anymore in the universal way it used to be accepted. And that is what was called now technical, Judge Wróbel said, technical populism. And I think there is so much truth in these statements. It's a very, very general attack, and it can happen in any of our EU countries or European countries. So these are my statements to Mrs. Gerstov's speech. Just a few statements to Mr. Majdowski's, Judge Majdowski's speech. what he said about rule of law, that rule of law is us, it's we are all responsible first. He said that there is no prefabricated model that we can just adopt, but rule of law has always to be developed and will be different in different countries. That it's necessary to have red lines, and then it can be endangered from within. I just sign all these statements on rule of law. That's my first statement. My second statement is that what he said makes reflect me on the relationship between diplomacy and law. I very much understand his answers to how he explained the judgment of beginning of May, and I think what we see here is a clash between the logics of law and the logics of politics. Because as a lawyer, you say you just work on your judgment and you want it to be consistent with within. You don't check if it's the good day to publish it. You just publish it when it's ready. But there, I think I have to put a question mark, because judges at constitutional courts and judges at international courts or European courts, they have a special responsibility. And I wonder if you don't have, if you can really just go ahead with this logics of law. There is a responsibility. I remember when at the European Court of Human Rights, we had to adopt a judgment on Yulia Tymoshenko. It was absolutely clear that it's a decisive difference if we adopt it before the election or after the election. There is no neutral point in time. And there I want to take up the valid point made by Judge Rule about time. Yes, our judgments very often come too late, and we have to think more about time. I have no real good answer, because what can you do as a judge? We always said we just continue working and then we adopt it when it's ready. But we have to see how it's taken then from the outside world. And the third statement to Judge Majdowski, he explained that the German Constitutional Court's judgment cannot be taken as an example for the Polish attitude to criticize the European Court and to find a way of not following the judgments. But I just want to say that Judge Majdowski started out by saying that rule of law means also if you dislike a judgment, you still have to obey. That is necessary for the authority of the judgments. And to create an exception, or as it said, an exceptional exception, or an exceptional exception, still means you don't always obey when you dislike it. And you find this loophole. And this loophole will be used, and it will be used out of context. And I think it's not possible for a judgment to define, to say you can use it only for this and under these and that conditions and circumstances. If it's used in a way to say, we abide by the judgments almost all the time, but we make an exception. And that is where I see the real danger for the European legal community by this judgment. And I'm not sure, Judge Rubel, if just a remark that is a specific answer from a German court would have helped in this way. I'm a bit skeptical. And now just three general remarks. I mean, yes, we can, how can we, what is our task? We can look at the past, we can analyze the past, we can look at the present time and ask ourselves what is now happening with, for example, legal certainty. I'm absolutely unsure if you look at our jurisprudence based on the newest Icelandic judgment of the European Court of Human Rights, that when I'm out. Do you still see me?
I hear you perfectly.
Okay, I was just, so I'm back in. Yes, we have the Icelandic judgment, which was referred to the Grand Chamber, where it said if the election of a judge is incorrect, then all the judgments adopted by this judge, by such a judge, are a violation of Article 6, right to an independent tribunal. So I wonder about the present situation in Poland based on this judgment, but we have to wait for the Grand Chamber judgment. But yes, let's look into the future. What can we do and what should we not do? The actors to react are basically is the Polish society, and there Judge Rubel has shown us very important ways how to react, and I think that's true for all the countries. And just to take up one point, you said that education is very important. Just to inform you, we have in Germany, we have set up a foundation which is called Forumrecht. And the idea is to show the functioning of rule of law, of Rechtsstaat, because we all, for us all, even for us lawyers, it's quite something abstract. And as we have a house of history where you can go and can touch things, we want to set up a Forumrecht where you can sort of touch the Rechtsstaat and where you have vivid discussions, where you integrate theater players, where you go to schools. So I think we are aware of that. It's a value we have to keep, and we have to do something for that. And I also completely agree that the language of our judgments might be rethought. Judge Majdowski said that there are 40,000 words. I ask, to whom are these 40,000 words directed in this judgment? The general community will not read these 40,000 judgments. They are for the legal community, but there might be also a question mark if I think of the Lüth judgment, which was some 20 pages and had a very strong message. I wonder if we lawyers are not sometimes driven by wanting to make it perfect, and then we create some text that is not read by everybody. So who can react? The Polish people, the EU neighbor countries like our countries, and in the next round, the question will be posed about the German presidency, and the Council of Europe, the European Court can react. I want to ask, perhaps on a general basis for us for discussion, should we react with, and now I ask for us lawyers, should we react with soft law or with hard law? I see really a dichotomy of reactions. Hard law is what the European Court in Luxembourg did, adopting judgments that are difficult to swallow. And then you have the real problem if these judgments are not abided by, if they are just rejected. Then you create a very, very general problem for the authority of the court in Luxembourg and for the authority of courts in general. The same is true for the European Court of Human Rights, where we had now complaints communicated about the situation of judges. When the court hands down judgments in such cases and they are not followed, we create a big problem. So hard law is better, of course, it's more effective, but if we are already at a point that it's not followed, we have a big problem. So in this sense, I really also advocate soft law. We have a lot of soft law instruments in the European Union, but we also have soft law instruments like the Venice Commission, which was already mentioned. Just last Friday, we have adopted an urgent opinion on Poland on the last changes and reforms. That is also quite a quick reaction. So I wonder if the situation that we are seeing, observing right now, does not call for materializing these instruments more. So my fear is, and there I take up a little bit the example or the metaphor of the house, but in a different way, used by Judge Majdowski in a different way. I'm sometimes afraid that reactions like those of the European Court in Luxembourg are like a fire brigade, extinguishing the fire, trying to extinguish the fire, but flooding the house, and then you have more water and you still have to tear down the house. So this is my real fear, because what I think is at stake is basically trust. The judiciary lives only and is efficient only if it's trusted. And that is true very much in Europe. And I see a lot of attacks on this trust in the judiciary right now. And that is what worries me most. Thank you very much.
Thank you very much for this very thoughtful presentation. I think we now should have a first round of reaction among the panel, including Judge Majdowski. So I'm asking Judge Majdowski, would you like to come in and give some comments on what you have just heard?
Yeah, thanks everybody. Mr. Robel, it was a pleasure to listen to you. I couldn't agree more with everything you said. The threat of populism is what we experience in Germany as well. A very tiny, small remark on one of your points. You talked about language, contemporary language. We do so as well. In our deliberations, it often takes hours or days to talk about our language. And, well, we do use the language of the 19th century now and again. And I agree with you that we should be modern in this point. But there's one little aspect I'd like to underline. The populism works on the thesis that everybody can judge on legal matters. So we don't need the courts. Weakening the judiciary is always the first step we experience when populism grows strong. So what we, I think, need is a twofold practice. On the one hand, we should underline that law is sort of an expert matter. Law, as you all know very well, is so extremely complicated now and then that it is not possible for everybody to cope with any legal matter or problem or question which is discussed publicly. What I think we need is to talk about our decisions in a language that everybody can understand. But there are effective limits to making the 40,000 words Mrs. Nussberger complained about understandable for everybody. So I don't have an answer which might be nice just now, but I think I take with me and in our panel your idea of modern language, but as I said, I want to stress that there are limits to this approach. Yes, Mrs. Nussberger, I was glad that you had only 3 remarks on my speech. That was nice of you, but indeed you cheated a bit because the 40,000 words was a 4th remark. Anyway, why did we take our judgment right now? It was the wrong timing, obviously, because we are in the midst of a crisis and everybody, well, has other things other questions to answer than just talking about a program which dates back a couple of years. But then still, diplomacy is a way of putting things in an understandable way. But for us as judges, we've discussed this matter a lot, and we've postponed the May date for about 2 months in order to have the technical possibilities to utter the judgment in a proper way. But we thought very strongly that it would have been unfair to postpone, say, another 6 months, because the European Central Bank obviously is setting up the next program, and not talking about our ideas about the PSPP program would have been unfair. They have not been part of our proceedings, but they are sort of addressees, and not knowing about our undiplomatically formulated judgment would have put them in a very difficult position, I think. So that's why we decided not to wait. And as judges, as you said, it takes years. For us, it has taken 4 years to get along with this case. And as you know, I'm talking about a majority vote. So in our deliberations, the room, it was not always the friendliest atmosphere. But having come to an end, everybody, all of us, all the 8 of us, thought that we had the duty just to let go, to tell everybody what we have decided and then wait for the criticism. What we do since. So the time problem. The exception problem. There, I'm afraid I don't have an answer you might have sympathy for. Because obviously, you're right. Life would be easy if there would be only one solution: obey the decisions of the European Court. We have been talking about an exception, in our understanding, occurring every 20 years. It has been the first in very many more years, the first time we didn't accept part of a ruling of the European Court. But the system we've set up, and the court has set up before I joined the court, as you know, bases on the idea of the identity of our constitutions. There are limits we cannot exceed. There are limits we have to respect. And if we want to change, really change,
Judge Madowski, you are frozen, so perhaps, thank you. Yes, you are still frozen, we can't hear you. So perhaps I have to come in with two pieces of information. The first is that we need to finish in 10 minutes because the commissioner wants to come in at 11:50. And I'm also informed to ask the general audience, so please, all these people, the 800 or more souls who are listening, there is at least a short possibility to ask questions, so please mail to questions@dimr.de, Deutsches Institut für Menschenrechte.de, dimr.de, to ask at least some questions, which will be highly interesting to us. At this point, Judge Wrobel and Judge Nussberger, perhaps you can also have a short reply among yourselves, and then we hope that there is time for at least 1 or 2 questions. So please, Judge Wrobel.
I don't hear.
You have to unmute yourself, please. Yes.
I was not so much criticized. I'm only happy that we agreed in many questions. Though while hearing to Judge Majdowski, which is perhaps not very gentle to speak about him without his presence here, but, oh yes, he's coming. But I think that what lacks, personally, I was touched by it. I didn't have much trust to the Constitutional Court of Germany that there was enough reflection on the influence of this verdict, of this decision on the other countries. Because otherwise, I would find something there in the reasoning of this, in this 40,000 words about this. And you know, it is only I have it for granted that you discuss it very deeply in this room, and you make the great deliberation on that. But let's give the sign of that.
Excuse me, we need to come to Angelika Nussberger, and then there is Dr. Baranowska, who also wants to come in, and we have just 9 minutes left, so please be patient with me. Angelika.
Yeah, but I think I need to hear the rest of Ulrich Majdowski's answer, because he was just about to say that he disagrees, and I want to understand. You just started with the exception problem.
in my opinion, I just ended with the exceptional problem, but that might have been lost in technique. I don't know. What I wanted to say is that this is a point we won't have an agreement upon. But as Mr. Wobel just now said when I rejoined the meeting, was what I do like to do and what we all should do very much more than we did, to keep up the international contacts we all have and had. In my experience, those contacts have grown very difficult with Poland, with Hungary, with Turkey, with all those states where populism is very strong. But what we need is the professional contacts between ourselves and the colleagues and, well, to the media in Poland, to everybody there who wants to listen to us and who wants to discuss matters. Because if we had more opportunities to do so, there might be more understanding. For me, it is, I know I have to explain that our deliberations, of course, touch political aspects and philosophical, ethical aspects and all that. For me, it is a matter of everyday work. But outside our building here, nobody knows so maybe. So what we can do to come a bit closer to each other, we won't agree on the point of exception fully, but to come closer to another is to have more conferences, talks, meetings, and whatever. That's a very practical and a very small point, I know, but it's a deficit we have, and we could do much more in this direction. As I know, the judiciary along the Polish border in Germany has huge difficulties to keep up the contacts to the Polish courts, which is a pity. And the populism in Poland, the government in Poland, needs to stop those contacts. That's why we need to keep them up. That's what I wanted to say.
Yeah. Thank you very much. Angelika, a further reaction from your side?
Just very, very short reaction because of time. I just claim, having worked in a European forum for many years, I just claim, Judge Madowski, that we are responsible for being misunderstood. I think we are really responsible for the possibility of being misunderstood. And I just want to mention the Gurgele, which also comes from your court. And as you know, the Russians have now adopted a judgment and bring it these days now into the constitution, a mechanism not to follow the judgments of the European Court of Human Rights, based on the famous last word of sovereignty that is always the reference. So, I mean, that's not how you meant it, that's for sure, but that's how it's received in other countries. And we are no longer judges who decide only for a specific country, a specific region, but we are read everywhere, and we have to be aware of how we might be misunderstood.
Good point.
Yeah. Now we have 5 minutes, and Dr. Baranowska, please come in, and perhaps you want to ask a question from your side, as time is so short, please come up, show up, and be part of the panel.
Hello. So first of all, thank you for all the great questions and comments that we have received over the last 2 panels, and keep them coming. We are reading them as they come. So I would like to start with one interesting comment that we got with regard to safeguarding versus restoring the rule of law. And that speaks to populism, one of the topics that all of you have mentioned in your speech, as well as to other comments as hate speech and fake news and other issues in Poland mentioned by Judge Wróbel. We also received one of the comments connecting the rule of law to women's rights in Poland. And the general questions that would come out of those comments and questions is, can restoring the rule of law be done with respecting the principles principles of rule of law, and what's the difference here between safeguarding and restoring? And in particular, we were asked about Poland, but also Hungary.
Thank you very much for that question. There are 4 minutes left. That makes 1 minute for each of the participants, and that should also be your final comment. I'm sorry we don't have more time. So we might go in the inverse order, and we start with Angelika Nussberger, then Judge Robel, and then Judge Majdowski at the end, if you agree with that. So please, Angelika.
In 1 minute, just to take up one of the questions asked, how can you restore rule of law if it's already gone the wrong way and then you want to come back? I think that is a central problem, because you have, for example, the principle of the irremovability of judges, and now you have new judges. So the principle of irremovability applies to them as well. So there I see a huge problem, but that's all I can say in 1 minute.
Thank you very much. That's Robel.
I can only agree with you. You know, it's the thing I'm wondering all the time, just thinking how to do this. It's the most complicated problem I have ever thought about in my whole scientific life. How could you develop a doctrine that would protect the judiciary from the new political equipe that will come, for example, yes? Because you can restore it using the politicians of the new regime, let's say, of the new movement, but then how to keep it safe and stable in the next political turn, yes? Because once you let the politician inside and build and rebuild the whole system, then you can't stop them. I don't know.
Thank you very much. I can suggest to you to look at the ideas of the opposition in Venezuela. They are facing the same problem, and they have been working it for a longer time. They have very interesting ideas how to rebuild the judiciary in a rule of law way. That's a complex thing for another seminar. Now we come to Judge Majdowski, please.
A Hungarian judge once told me that he feels to be forced to decide certain cases as the government likes them to be decided, but he takes the freedom to decide all the smaller cases following the rule of law. I don't know if this is a good idea, splitting judges in two halves. I'd rather not. But what I think we can suggest is start with the small cases, with the lower instance courts. Start to restore the rule of law in the heads and in the hearts of judges working there, and do it by international contacts. And then things will build up, hopefully. I don't think it's a good idea to start at the highest point you can possibly get, the Constitutional Court, if this court is lost. But start at the first instance courts. It's where everything starts in our judiciary. Yeah.
Thank you very much. That has been a wonderful panel, and we even finished precisely on time at 11:50. Thank you very much for the contribution. Thank you for being so disciplined. I think it has been a great moment. So I hand over to the organizers. Thank you and goodbye.
Ja, ganz herzlichen Dank.
Yeah, thank you so much to the four of you. I have to say, especially the moderator Armin von Bogdandi. You handled that very well to keep to the schedule. You all noted we need more talks, more intensive debates about these topics. We had a chance to start that. Unfortunately, this electronic format is not appropriate for having full-day meetings. This is why we have to stick to the limited time frame. So this is unfortunate, but it worked out well. So thanks for that for the moment. The second panel that will start now has the topic, how can the rule of law be secured in Europe? It's more forward-looking, and as moderator for the second panel, we have the publisher of the Verfassungsblog, the constitutional blog, Maximilian Steinbeiß. He is here in the Bremen representation, and you will see him in a moment. He worked for 10 years as an editor for Handelsblatt on a political side, and is today a free publisher for law and publishing. And in 2019, he started the Verfassungsblog in order to deal with legal and constitutional topics at home and abroad. This has become one of a key authors' blog discussing important matters also in the context of European integration. We are very pleased now, however, for the second panel as a co-debater, but also as an opening speaker, to welcome the Commissioner of Justice of the European Commission, Didier Reynders, who joins us from Brussels. He is a lawyer and has held many roles in his life I don't want to or can't relate to in this time. In 1992, he went for the Wallonian Liberal Party to the Belgian Chamber of Deputies, and we know him that between 1999 and 2011 he was Belgian finance minister, and then was member of 3 governments in Belgium as foreign minister. Since the 1st of December 2019, he is a commissioner for justice and rule of law in the commission of Ursula von der Leyen. Mr. Reynders, we're pleased to have you. Over to you.
Ja, wir haben.
Well, once more, we have some connection problems, in this case with the Commission in Brussels, and we hope to be able to resolve that soon. And this is why we would rather now get into the panel discussion that was planned. The moderator, Maximilian Steinbeiß, had already been announced by me. Besides Didier Reynders, who will also be on the panel, we have got Irina Speck. She's responsible for policy matters in the German Foreign Office. A warm welcome. Then also the 2 hosts, the Polish Ombudsman, Professor Dr. Bortmann, and my colleague in the German Institute of Human Rights on the board, Professor Dr. Rodov, and Mrs. Adamovich, member of the European Parliament, and she is the wife of the murdered Gdansk mayor. For the moderation, I pass the floor to Maximilian Steinbeiß, who will facilitate the panel. Now, over to you.
Kind words of introduction. I guess we 3 months into the corona crisis, we're still treading uncertain grounds in these kind of hybrid conferences, Zoom meeting kind of things. So we'll, without further ado, jump right into the panel discussion. And I would like, since our topic for this discussion is what to expect of the German Council presidency, which is about to begin, I would like to direct my first question to the representative of the German government, Irina Speck. The Council hasn't struck me as particularly eager to pick a fight with a member state and its government, which undermines the rule of law in recent years in the EU so far, to say the least. And is this going to change under the German Council presidency? And if so, how?
Thank you very much for including me into this panel, and it's really sad that Commissioner Reynders couldn't give his keynote speech, because I think he would also lay the ground for what we will take up when we take over the German Council presidency next week. So what I can tell you is that the rule of law will be very high on the agenda of the Council presidency, and this is for very obvious reasons. Rule of law is not a nice to have, but is sine qua non condition for the functioning of the EU. Rule of law is the safeguard of safeguards, and in the end, the foundation stone of our shared rules-based community in Europe. We've seen this urgently in the last month of crisis, when the rule of law got under pressure also in the EU. This is the moment in which we really need to demonstrate how serious we are about the rule of law. So under our Council presidency, we will focus on several strands, and that's maybe already coming to your first question. One strand will be the Article 7 procedures against Poland and Hungary. Where there's a deficit in compliance with the rule of law, the mechanisms envisaged in the European treaties must be resolutely employed. That applies both to proceedings in accordance with Article 7 of the Treaty on the European Union and to proceedings before the European Court of Justice. We will support the Commission and the European Parliament in the Article 7 procedures they have launched with respect to Poland and Hungary. The second strand we will focus on is EU budgetary funding and its compliance with rule of law standards. That's why we will be also working to see the provision of EU funds more strongly tied to the adherence to the principle of the rule of law. This will play an important role in the upcoming negotiations on the multi-annual financial framework, once the heads of state of government have concluded their position as the Council. Compliance with rule of law standards in the EU and its member states is a basic prerequisite for the correct use of funding from the EU budget. The mechanism, and I'm sure Commissioner Reynders would have elaborated on that or will later do so, the mechanism would apply if there are general deficiencies of the rule of law in a member state that endangers the budgetary management in relation to EU funds. The Commission could then take measures to address the problems, including reducing or restricting funding in a proportionate manner. We support the Commission in this endeavor in making EU budgetary funding dependent on compliance with rule of law standards in the member states. When you look at the instruments I just elaborated on, you can see they are all corrective measures. They only take effect once the fundamental principle of the rule of law has already been clearly violated. But what's missing so far is a preventive mechanism, a forward-looking and cooperative mechanism involving all member states in the same way and on equal footing, a mechanism that allows for a constructive dialogue among equals in order to learn from each other and create mutual understanding about how to best deal with rule of law issues. A mechanism that prevents the difficult situations from even arriving. This is what we would like to put on track in the Council under our presidency. What we want to create is a preventive instrument that will enable us to engage in an open and constructive dialogue about the rule of law, as we have not seen that before. And that is where the work of the Commission and the plans for our presidency come together. The Commission announced that it will present its first an annual rule of law report in September. So maybe, I don't know if Commissioner Reynders is coming in now.
Yes. Sorry, please go.
I just said that you will present your first annual rule of law report in September. And you clearly expected the Council and the European Parliament to provide a comprehensive follow-up. As presidency, we feel we bear a particular responsibility. As we said, we will set a precedent for future presidencies on how the Council deals with the Commission's report. So on the basis of the Commission's first annual rule of law report covering all member states, we want to start a regular, open and critical rule of law dialogue in the Council. Developments across Europe will be addressed, as will all country-specific chapters. In this mechanism, all member states will submit themselves to a reciprocal review of the rule of law. It will take the form of two discussions, and that's how we envisage it. An annual one on the report as a whole and its horizontal aspects, and a half-yearly one on the first country-specific chapters of the report, so that all member states, step by step and in turn, will be covered. Our goal is to foster a better understanding of the situation in each member state, identifying risk at an early stage and being in a position to offer reciprocal support. We believe that looking not only at cross-cutting issues, but also providing for a country-specific discussion is particularly important because rule of law issues are typically not the same all over Europe. They are very specific to the judicial, constitutional, and political systems and traditions of every single member state. Judge Majdowski said this earlier on in the first panel. So we would like to give every member state the possibility to explain the developments mentioned in the Commission's report in the context of its own traditions and its system. During our presidency, we want to put a focus on this forward-looking constructive dialogue amongst equals because we deeply believe that we should return the rule of law to what it ought to be, not something that divides us in Europe, but really that unites us in Europe, a culture of rule of law. Or to put it with Judge Majdowski's words, rule of law is all of us. That's how he started his speech in the first panel. Thank you very much.
Thank you very much for this introduction. I understand that Commissioner Reynders is now with us, and we already have heard from him briefly. And the floor is yours, Commissioner.
If you hear me, I will maybe explain how we are working about our capacity to uphold the rule of law and in all the member states at the EU level. I will be very pleased to see that it will be with the support of the future German presidency. And it was very useful to listen to the way to organize the German presidency in the next month. And of course, the rule of law, you know, that is one of the fundamental values of the European Union enshrined in Article 2 of the Treaty on the European Union. What makes the rule of law so important is that it guarantees the respect of all other values, including democracy and fundamental rights. In fact, it's the European way of life. It's that the real definition in the Article 2 of the treaty. I'm particularly pleased to discuss about the rule of law in an event organized by national human rights institutions, which have a key role in upholding the rule of law and fundamental rights in the member states. National human rights institutions are essential for making the rule of law and the Charter for Fundamental Rights a reality for all. They monitor the situation at national level, provide advice to governments and parliaments, investigate, adopt recommendations, and engage in strategic litigation. They can help citizens, in particular those more vulnerable, to know more about their rights and how to enforce them. Also, they carry out important education and awareness-raising activities. As you know, recent developments in Europe have put the rule of law on top of the EU agenda. And I'm aware that in certain member states, national human rights institutions have also experienced blows to their independence and effective operations over the past few years. These developments raise important questions. Let me start by recalling that the organization of justice is a competence of the member states, who are required to comply with EU law when exercising this competence. Safeguarding the rule of law is therefore in the first place, the responsibility of each member state. However, the Commission also has a responsibility for the rule of law in the Union, and the Commission already has what is often referred to as a rule of law toolbox. Such tools include, for instance, the country-specific recommendations in the European semester, or the EU Justice Scoreboard, which provides comparative information on national justice systems in the EU as regards their independence, quality, and efficiency. And we will publish the next Justice Scoreboard next month in July. There is also the well-known possibility to launch infringement proceedings where EU law has been breached. In recent years, we have seen the European Court of Justice develop an important case law in this regard, where it emphasizes the link between the rule of law and respect of EU law. But it is clear that we need to do more and think outside of the traditional toolbox. Last year, the Commission therefore launched an important reflection process. The result was a communication by the Commission in July 2019, focusing on 3 themes. First, we need to promote a rule of law culture among the general public. Second, we have to prevent rule of law problems from emerging or deteriorating. And third, response. We need to reflect on the ways how to react more effectively to significant problems. From day one, President von der Leyen committed to carry on this work forward. Today, I will focus on what that means concretely. As regards promotion, building a rule of law culture is about making EU citizens better aware of what the rule of law actually means for them. This requires further efforts to improve knowledge in the general public about the rule of law standards and requirements set by EU law. National human rights institutions can play a valuable role in this context, including through the organization of debates such as this one today. I'm also grateful for the dedicated work of journalists and academic fora on this topic, such as the Verfassungsblog in Germany. The Commission is committed to support stakeholders and civil society in their efforts. Our justice funds provide important support for a number of civil society organizations. And I'm happy that in the Commission's draft budget for 2021, which the College adopted this week, we have avoided cuts in these funds. So it will be possible to continue to provide support to the civil society and to any organization in such a kind of process. The second major part of our work is about prevention. This is about detecting and remedying rule of law issues at an early stage. To do this, we need a better understanding of the situation of the rule of law in the whole European Union. This is what the new comprehensive European rule of law mechanism is all about. As Justice Commissioner, I have the honor to lead the Commission's work on this file. As part of this new mechanism, I'm coordinating the Commission's work on the first annual rule of law report, which will cover all 27 EU member states on an equal footing. Our services are monitoring significant developments, both positive and negative, in 4 areas: the justice systems, the anti-corruption framework, certain issues related to media pluralism, and other institutional issues related to checks and balances. In this framework, we are also monitoring the situation of independent authorities, including national human rights institutions. Finally, and where relevant, the report will also reflect recent developments with regard to emergency measures adopted during the COVID-19 pandemic. So far, we have received written input from all EU member states, but also from over 200 stakeholders. Classical ones, like the Fundamental Rights Agency in Vienna or the Council of Europe, but also many organizations in all the member states coming from the civil society. These include, of course, the contribution from the open network of national human rights institutions. I know that both the Polish Commissioner for Human Rights and the German Institute for Human Rights have also provided valuable inputs. As a next step, my services have in recent weeks been conducting virtual country visits in each member state, including Germany and Poland. I'm grateful for the more than 300 meetings with national authorities and stakeholders, which were cooperative, open, and informative. In this context, my services also had a very insightful exchange with Mr. Bodnar on the current situation in Poland. Thanks to all the input received, we are making good progress and remain on track to publish the report in September as planned. Once the report has been adopted by the College, it will then serve as a basis for the incoming German presidency of the Council to quick start a genuine political debate on the rule of law between the member states in the Council. And I thank the future German presidency for the support to organize such a debate, maybe first on with a general approach on the annual report, and then member state by member state during the presidency, and maybe during the next presidency, for example, with Portugal at the beginning of next year. This political debate also needs to take place in the European Parliament and in the member states, notably in national parliaments and with civil society. I can assure you that I'm fully committed to do that. It will be the best way to try to install a real culture of the rule of law in all the member states and in the civil societies of all the member states. National human rights institutions will have an important role to play in sparking a debate around the report at national level, and I count on your support in this regard. The aim is to start a regular annual cycle and provide the impetus for the EU to address challenges for the rule of law in a cooperative way. Let us now turn to our third strand of work, the response. Our work on establishing a better rule of law culture in the EU and on preventing problems from emerging cannot replace remedial action where it becomes necessary. Let me start with infringement proceedings. Where the independence of the justice system of a member state has come under threat, the Commission can bring infringement proceedings against this state. For instance, to protect judicial independence in Poland, the Commission has seized the Court of Justice a number of times, and each time with success. Let me say a few words regarding the ongoing infringement proceedings against Poland. On 10 October 2019, the Commission decided to refer Poland to the Court of Justice regarding the new disciplinary regime for judges. The reason was that this regime undermines judicial independence by not offering the safeguard to protect Polish judges from political control. On 14 January 2020, the Commission decided to ask the Court of Justice to impose interim measures on Poland, ordering it to suspend the functioning of the disciplinary chamber of the Supreme Court. On 8 April 2020, the Court of Justice ruled that Poland must immediately suspend the application of national provisions on the powers of the disciplinary chamber. The order, which confirms in full the position of the Commission, applies until the court will have rendered its final judgment. On 8 May 2020, the Polish authorities provided the Commission with a report that set out the measures taken for implementing the interim order of the court. After carrying out an analysis of this report, the Commission was not in a position to conclude that Poland had taken all the necessary steps to comply with the order. For this reason, on 5 June 2020, I sent a letter to the Polish Minister of Justice in which I explained our concerns and asked for clarification and further information from Poland by 24 June 2020. We have received a response at night yesterday. Moreover, As regards the Polish law on the judiciary, the new Polish law on the judiciary, the so-called muzzle law, the College decided on 29 April 2020 to open a new infringement procedure. We have carried out a careful analysis of the legislation concerned. On that basis, we conclude that certain provisions adversely affect judicial independence, the principle of primacy of EU law, the functioning of the preliminary ruling mechanism, the Charter of Fundamental Rights of the European Union, and the General Data Protection Regulation. The Polish government still has until the end of this month to reply to our letter of formal notice. But the EU has also other means to keep up the pressure to protect the rule of law. One is the procedure set out in Article 7 of the Treaty on the European Union. This procedure can be triggered where there is a clear risk of a serious breach by a member state of the values referred to in Article 2 of the Treaty of the European Union, values which include, of course, the rule of law. This procedure provides for the most serious sanction the EU can impose on a member state. I mean, the suspension of its voting rights in the Council. The launch of this procedure, first against Poland by the Commission and then against Hungary by the European Parliament, is an unprecedented step in the history of the Union. I'm convinced that the Article 7 procedures should continue as long as the situation points to serious and systemic threats to the rule of law in these member states. Even though this contributes to keeping political pressure on the member states concerned, Article 7 can only be one tool among others. One reason for this is, as you know, that its voting procedures to adopt recommendations or sanctions in the Council are particularly demanding. The last reactive instrument of our toolbox is not yet operational. This is a proposal for a mechanism to protect the EU budget in case of breaches of the rule of law in a member state. It is currently being examined by the European Parliament and the Council. If this proposal is adopted, it could make a very important contribution to protecting the rule of law in the EU. In this respect, I also count on the support of the incoming German presidency, because it will be very important to organize such a conditionality between the funding of different policies and the rule of law. And certainly, if we have an agreement on the new MFF and the next generation EU, because that means that we will spend maybe more money faster and with more flexibility than in the past. So it's very important to organize a real protection of the EU budget. We will do that with the installation of the European Public Prosecutor Office, but we need also to do that with a real conditionality between the rule of law and the funding of the different policies. And of course, I said that we have some problems in the use of Article 7 due to the procedural rules and the qualified majority or unanimity that is required in some steps in the Article 7 procedure. Is the reason why I insist on the fact that about the conditionality and the new legislative proposal is of course important to work with the reverse qualified majority to have a certainty that it will be possible to use such an instrument. In conclusion, if I may, let me say that the Commission remains committed to use all tools at its disposal to uphold the rule of law in our Union. We are just added some new tools. We don't want to suppress anyone, so we'll continue to work with infringement proceedings, with dialogue, with Article 7, with all the different tools at our disposal. We have just from September a new tool with the annual report and maybe another new tool with the conditionality related to the MFF and the financing of different policies. National human rights institutions are important partners for the Commission in this regard, and I'm grateful for the opportunity to discuss with you today, and maybe just a last word to say that when we will have published the annual report on the rule of law in September, I said it will be important to discuss with the German presidency at the Council level, to discuss also in the European Parliament, this report, but also to go to the different member states to discuss at the national level with the parliaments, with the civil society. And again, I count on the national human rights institutions to take part in such a process and to help us to install a real culture of the rule of law in all the member states. Thank you very much for your invitation, of course, and your attention.
Thank you very much, Commissioner Reinders, for this keynote. I understand you have to leave early, so let's swiftly proceed with our panel discussion. Ombudsman Bodnar, I think we all are aware of the sensitivities which exist in Poland towards what some may consider German attempts to meddle with Polish internal affairs, which is high for obvious reasons. And to which extent do you think the German Council presidency will have to tread lightly when it comes to rule of law issues in Poland? And what in general are you expecting, what are the expectations of the Polish people, of the citizens of these 6 months to come, in your view?
First of all, I want maybe to, yeah, please.
Okay, Maximilian, so who is having the floor right now? Me or Commissioner?
Mr. Bodnar, please. No, please, okay. Mr. Bodnar.
Okay, fantastic. Ladies and gentlemen, thank you very much for accepting our invitation to participate in this important conference. And I would like to thank our partners from the German Institute for Human Rights for making it happen. I'm very happy that I can speak after Commissioner Reinders and his statements concerning the plans for the Commission. And it seems to me the most important point is that the German presidency basically should work together and should cooperate with the Commission on issues concerning rule of law. I think it is of utmost importance that there is a cooperation and that there is a strategy, because after all those years, more or less, we know what works and what doesn't work. And maybe I would like to concentrate on some of those issues. First of all, I would like to say that I'm just almost 5 years in service as the Ombudsman. So my term comes to an end. And I remember that basically there were like two major topics during my term. One topic was rule of law, and it is still an ongoing issue, as you know. And second is something what I would name as so-called attempt to make an illiberal change in Poland and trying to resist this illiberal change. And just recently we observed like another step in this process concerning protection of LGBTI rights. But I would like to follow to what Professor Grubel said about this need to explain the value of rule of law and the protection of constitutional rights to our citizens. Over my term, I have visited more than 200 Polish cities where I had meetings with citizens, and I really believe that they need to have a deep understanding why they do have rights, why those rights are important for them, and why they shouldn't allow for those rights to be taken over from them. So we really need to invest a lot of time, energy, and our, let's say, creativity, how to push for the proper civic education and education on rights. I think we shouldn't forget about this value. Second point, for sure, I will not go into details concerning all those institutional changes that happened in Poland, but I think this so-called, the famous theory of salami slices is applicable here. So over those last 5 years, we observed the process of cutting off the independence of different institutions. And of course, European Union has been intertwined in different processes, but also especially in terms of reaction. And I think one of the major lessons we are having is that the ruling majority in Poland is basically taking the advantage of the time. Because after a couple of months, after a couple of years from some initial changes, it is much more difficult to deinstall or to stop any changes that have been made in the legal system. Just look at the National Council of Judiciary. We have this discussion about expulsion of the Polish National Council of Judiciary from the European network of councils of judiciary, but it takes time, and it is also quite difficult to stop the operation of the organ, which is having this primordial scene in terms of being composed with the huge influence of the executive power. And in the meantime, the National Council is taking a lot of decisions. And it seems to me that if you look back, like the good and important lesson for us is 2018, when upon the infringement action of the European Commission and later on interim order of the Court of Justice, it was possible to stop the process of sending judges for early retirement from the Polish Supreme Court. That was really a great success, 19th October 2018, when this interim measure has stopped the process of really detrimental changes in the Supreme Court, and 20 judges could return to adjudication. Right now, obviously, we are in a much more different and more complicated moment. Because first of all, we know that the judgment of 19th November 2019, which challenged the process of nomination of judges made by the National Council of Judiciary, this judgment to great extent has been challenged by the Polish authorities as a result of adoption of so-called muzzle law. It's good that muzzle law is subject to of attention of the European Commission, and then the infringement action has started. And I really do count that after this exchange of letters, and we can almost predict what is in those letters, sooner or later this case and this law will end up in the Court of Justice of the European Union. But I think we should be concerned with two other issues. The first issue is whether the interim order by the Court of Justice concerning disciplinary chamber and disciplinary judges in the Supreme Court is really enforced. Because my feeling is that this judgment is simply not enforced at all. And moreover, some actions by the authorities which are taken are just obvious declaration of lack of willingness of any compliance with this judgment. Just recently, Judge Tuleya, one of the most famous Polish judges, has been subject to the procedure concerning lifting of the judicial immunity by the disciplinary chamber, and it happened just 2 months after the issuance of the interim measure. I think it is really important because if the European Union is allowing that the EU law is basically ignored, or basically it is used or it is applicable based on the principle of cherry picking, it shouldn't be. It doesn't mean anything good for the future of the European integration. But in this context, I would like also to mention another process, which could be especially important in the terms of safeguarding rule of law in Europe, which is the use of the European arrest warrant. After this famous Zelmer case, we are at a completely different stage. We are at the stage where certain domestic courts are already refusing to surrender Polish individuals on the basis of the European arrest warrant by referring to problems with the judicial independence. And I think it is the issue for the European Commission, but also for the German presidency, to look at this and to check what are really the consequences for the mutual recognition of judgments and mutual cooperation in legal matters of this problem with the rule of law in Poland. Because the recent decision by the Landgericht in Karlsruhe, in which this court has refused to make a surrender, but also the recent decision of the Slovakian court not to refuse a Polish individual, is really something important from the point of view of future integration. I'm glad that we are talking about, and I do appreciate the effort by the Commission concerning the annual report on the rule of law. But I must say that I'm afraid of one thing, because we can enter into one more additional discussion, one more additional review, one more additional evaluation. But what is at the essence is the time, because after 2, 3, 4 months' time, the situation will be once again much more different than it was. So here, in my opinion, it is important to have something like a strategy, but also a strategy which encompasses a certain effect that should be achieved. Like, for example, even if we look back into the muzzle law, I remember that Commissioner Jourova was in Poland in January this year, at the end of January, and we expected that basically the case in the Court of Justice will be pretty soon. And of course, I understand that there are certain procedures to be completed before the case is turned to the Court of Justice of the European Union. But it seems to me that in September, reality will be once more a little bit different than it was, let's say, in spring. And maybe those procedures could be completed earlier. So I think that taking the element of time is really important in this context. I would like to refer also to one topic which was mentioned in the previous panel, but I think it is of great importance, because here on this rule of law scene, we have like another actor. Finally, we have another actor. I mean here, the European Court of Human Rights. European Court of Human Rights might be a crucial actor in safeguarding judicial independence, right to court, but also the situation of preserving the situation of individual judges. And Judge Professor Angelika Nussberger used this nice comparison to the fire brigade, that both the Luxembourg and Strasbourg court could be like a fire brigade. But unfortunately, I can say this about the Court of Justice, that they are really trying to work as a fire brigade by making all those different cases, interim orders, and so on. But it seems to me that with the European Court of Justice, the fire truck has just get out of the fire station, and it is still far away from getting to the place of fire. We have a couple of cases that have been communicated, but still we don't have even, some imagination what are the dates of hearings or dates of judgments in those cases. And if we will have judgments, let's say in 2-3 years time from now, they would not really matter, So it is important to take that the European Court of Human Rights should take things in Poland, in Hungary, in other member states of the European Union seriously. Just to conclude, I would like to say that what is at stake now, it's not just the future of Poland. President Małgorzata Gersdorf has used really very dramatic words to describe a situation in Poland. It is a future of European integration, because this European integration is based on the mutual recognition of judgments and mutual legal cooperation. It is based on the common protection of European values. But it is also, and I would like to underline this, it is also a story of individual judges who are putting at risk their individual careers. We can talk about number of institutional issues. We can talk about number of solutions, but one of those judges, Judge Juszczyszyn, the judge who started to apply directly the EU law, has been suspended as a judge, and his salary has been cut by half. So he is one, like a very practical, very concrete, specific example of a judge who is suffering. We have a number of judges who are facing explanatory or disciplinary cases these days. We shouldn't forget about them. We should think that their sacrifice is in order to save not only Polish democracy, but it is in order to save democracy at the European Union level. So please, let's have it in mind that it is not just an institutional discussion, it is a discussion about real sacrifice and lives of dedicated judges and other civil servants. Thank you very much.
Thank you very much, Adam Bodnar. You mentioned the fact that the courts, the European courts, the fire brigades have left the station, but are still far from reaching the fire. And the Article 7 procedure has been around for years now, and it's hard to see how they can proceed in a more promising way than they have so far. So there's one thing that is really making a difference, and many place their hopes into that one, and that is hitting those governments where it really hurts, and which is the money. And both Commissioner Reinders have mentioned, and Ms. Speck have mentioned the proposal about making funding from with EU money conditional with respect for human rights and the rule of law. Professor Rudolph, is conditionality really the key to fix this problem?
Well, I don't think there is one key to preserve the rule of law. I think what we need to do is to use all the instruments that are available, because the rule of law is so fundamental and is the fundament, actually, of the European Union. Can I just add to what Adam Bodnar said, and that is, I think the independence of the judiciary is not a question of national sovereignty. It's a question of common European standards, and it's a question of our fundamental rights. It is a question, therefore, for all of us. And so, therefore, I think we all in Europe have to act. We all in Europe have a right to an independent judiciary. That is enshrined in the European Charter of Fundamental Rights. That's enshrined in the European Convention on Human Rights. And I think it's been rightly said that preserving the independence of the judiciary is key to the future of the EU as a community based on the rule of law and a community of values. Now, I think really this is a test of adherence to the European values. I think all true Europeans must join hands and use what is at their hands to uphold the rule of law wherever it's challenged in the European Union. I would like to emphasize that it's concerned citizens that must continue to protest to attacks on the independence of the judiciary. Citizens, the media, national human rights institutions need to hold to account those that undermine the rule of law. And as we've heard, judges and prosecutors all over Europe have an instrument at hand. They must reject to apply judgments that are rendered by courts that are not independent. And governments, individually and collectively, must insist that the European member states, all European member states, implement the judgment of the Court of Justice of the EU. And the European Commission must continue and step up initiating infringement procedures when a state infringes upon the independence of the judiciary. And the Commission, national human rights institutions, civil society must monitor the implementation of those judgments and the development of the rule of law. And although you were skeptical about the Article 7 procedure on determining whether there is a serious and persistent breach of European values, I think it is important to, again, step up that procedure. I think it would be an important message if the majority of the European Council would emphasize that it is against the spirit of the procedure that any government participates in those procedures if it itself is under review. So that's not in the text. There's only the unanimity versus one. But I think we need to speak out that those governments who are themselves under review may not participate in procedures concerning other states. But lastly, as you said, the EU must make sure that the funds of the Union are only spent in member states that have an independent judiciary. I think we've heard from Commissioner Reinders that this is necessary to protect the funds of the EU. That means it's necessary to protect taxpayers' money. I mean, how can a government explain to its population that their hard-earned money will be spent in another member state without an independent judiciary, without independent control? But I think even more, I think it's independent courts protect the people, all people, and not just those that are close to the government. So the European Union should not support financially a government that withholds independent judicial protection from the people. In my opinion, therefore, this type of conditionality is an applied European solidarity.
Thank you very much. Judicial independence is not the only challenge we are facing in the EU right now with respect to the rule of law and also to democracy and human rights. Another would be hate speech and disinformation campaigns at the hands of governments or government-sponsored private actors. And this brings me to you, Ms. Adamovich. With respect to the combat against hate speech and disinformation, what would your expectations to the German presidency, council presidency, would be?
Do you hear me?
Yes.
It's just to ask if it's possible just to take the floor 2 minutes, because I need to leave. So but I want to react maybe at what was said by Mr. Bodnar and the professor. 2 minutes if it's possible.
Okay.
Thanks. Okay, thank you. No, I want just to say that, of course, the professor has said that we need to use all tools that we have at our disposal. It's very clear. And of course, it's very important to have the citizens on board in the debates that we are trying to organize about the rule of law. But I want to insist on the fact that I don't want to interfere in the electoral process in Poland for the moment. I want just to make three remarks. The first one, about the judges. I fully understand the remark of Mr. Bodnar about the individual judges and the risk that they have taken in the last months and years. And it's one of the reasons why I've asked to the Commission to ask interim measures. And I said we have received yesterday a response from the Minister of Justice and the Minister of European Affairs. Of course, it's now the task of my services to analyze the content of the response, and we will see what is needed to do or not on such a basis in the near future. The second remark, it's about the German presidency. Again, I will be very pleased that we will organize a debate about the first annual report on the rule of law during the German presidency, not only in general, but also country by country, member state by member state. It's a real peer review. So it will be, for the first time, a real pressure from the different member states about the rule of law on all the orders. We'll continue to use Article 7. Of course, we know the difficulties that we have with the procedure rules in the Article 7, but we need to continue during the German presidency to use such an instrument. And of course, I'm hoping that it will be possible to make some progress, to do some progress in the conditionality about the funding. And I insist again on the reverse qualified majority in such a process. And my last remark is to say that it's of course very important, it was said by Mr. Bodnar, that the EU institution and the Council of Europe play an important role to support the rule of law in all the member states. And so the two courts, in Luxembourg and in Strasbourg. But it's also important to support a real debate at the national level in all the member states. Because without a real discussion with the citizens about the rule of law, it will be difficult to make real progress. Of course, we have some tools at our disposals to try to push pressure, to organize a real process, but we need, again, to have a real debate at the national level. I want just to say that, because sorry, but I must leave because I have now a meeting with some ministers during the Croatian presidency. But thank you very much for this seminar, this webinar, and I'm hoping that we will have the opportunity after the publication of our annual report in September to come back and to discuss again at the national level the content of such a first annual report on the rule of law. Thank you very much.
Thank you very much, Commissioner Reinders, and thanks for being with us. Now let's return to Ms. Adamovich about hate speech and how to combat it.
So, dear sirs, thank you very much for invitation for this conference and for taking up such an important subject. So, without any doubt, the German presidency of the Council begins at the difficult time. This requires unprecedented efforts from across the social, economic, and political spectrum. European values are under threat. Of course, the whole world has been trying to tackle the COVID-19 pandemic and its consequences. However, in my opinion, one element is missing from the picture. I mean, support for democracy and restoration of the civil rights and fundamental freedom. So we need now more than ever in EU an ambitious multi-annual financial framework. It cannot be a budget based only on the economic recovery. The coming weeks will be marked by crucial negotiations between EU member states, in order to adopt MMF 2021-27 in due time, ahead of the EU Leaders Summer call for 17-18 July. Let me appeal to them to find the strength and persistent to adopt the ambitious principle for MMF. Surely it will be a difficult task in the current situation. It is more difficult than it has ever been. However, we cannot focus only on post-pandemic economic recovery. The EU's next 7-year budget will define our approach to what is important. While saving the economy is at stake, we cannot lose a bigger picture. Defense of democracy needs to be one of our main priorities. Focusing just on saving the economy would be short-sighted. Therefore, we need also increase the social reliance and restore public trust in the state and its institution. And civil society is going to play a crucial role in this respect. The European civil society and independent media are going to be instrumental for full restoration of the EU fundamental values of democracy, human rights, and the rule of law. This post-pandemic recovery cannot make us lose our ambition in regard to support of democracy and upholding its values. Initiatives such as the EU Democracy Action Plan, Media Action Plan, or Digital Service Act cannot be downgraded due to other priorities. Finally, the proposed enormous cut to Rights and Values program cannot be accepted. It is precisely this EU program that it's supposed to uphold the EU fundamental values and support civil society and grassroots organization. We cannot leave our civil society without resources they so desperately need. Let me also say a few words on the issue of the fighting against hate speech. As you may be aware, it is an issue particularly dear to my heart. Hate speech can not only misinform people, but it can kill. Online hate speech and disinformation are increasingly used as tools to increase social polarization and exploited for political purpose. Combating them is not only relevant to the domain of human rights, it is also a fundamental factor in terms of define of the rule of law and democracy in the EU. I would like to emphasize that I'm not talking only about the protection of media freedom, the fight against disinformation and hate speech as our moral duty. They are the very cornerstones of our defense of the democracy. The fight against media capture, hate speech, and misinformation does not only concern the area of human rights, but it also becomes a major task in the EU field of defense of the rule of law and the democracy in the EU, which is a major condition for survival of the EU. Allow me also to remark that this appeal goes hand in hand with my previous argument regarding ambitious financing and emphasizing on the initiatives tackling threats to democracy and media freedom and pluralism. When we need to be clear about our condemnation of hate speech. The climate of impunity in the digital sphere further increase in damaging potential of online attacks and harassment. I'm very much aware of the criticism surrounding several legislative initiatives at the national level. They are criticized for trying to counter hate speech, but failing to adequately take freedom of expression into consideration. I would like to stress that we need to focus on the tension between justified freedom of expression and unjustified permissibility of hate speech. This is a crucial task for the EU in its work on the proposal for the Digital Service Act. All our actions and legislations must absolutely take into account the protection of freedom of expression as one of the basic human rights. However, when the right to the freedom of speech is used as a tool for mass manipulation, leading to the annulment of democracy, it becomes the antithesis of freedom. Freedom cannot be used to enslave. Democratic procedures cannot be used to destroy democracy. The remedy for using freedom of speech to manipulate society is to increase media freedom, independence and pluralism, access to information, including the protection of reliable journalists, and finally, support for media literacy. Those not only should be our priorities, they have to be. Thank you.
Thank you very much, Ms. Adamovich. Now let's open the floor to the questions and remarks from the audience. Katarzyna Baranowska has collected your input, and please.
So thank you again for all the questions and comments. And one of the topics that I would like to raise and address to the panelists is the misunderstanding or the lack of understanding of the rule of law and the role that can be played by various actors. As Judge Ulrich Majdowski said in the very beginning, there are some red lines with regard to the rule of law, even if we look at it from different sides. And here, there's the role of lawyers, of public officials to engage with the public, to explain and to educate about certain issues. Let me start with saying that the author of the first question that I asked in the beginning, safeguarding versus restoring the rule of law, was Professor Wojciech Sadurski, who is a legal academic very involved in this action, engaging with the public and informing about the rule of law. Judge Wojciech Wróbel has explained how judges can be involved in such actions. And in fact, as we can see in Poland, in many situations, this really is taking place, and judges are very active in explaining the peculiarities and also many details concerning the developments in Poland. Judge Angelika Nussberger talked about how judges are responsible if they are misunderstood, and I think that's also a very strong statement today. And in this panel, we also talked about the role that local communities can play and national human rights institutes. So what I would like to address coming out of the questions from the audience is what role national human rights institutes, judges, local institutions, and governmental institutions can play in engaging with the public in the context of the rule of law. And some of you from the audience have raised doubts whether in the context of engaging in those actions, the independence of those institutions is endangered. So I would like the panel to address also those doubts, whether they in fact are valid. And it would be great to get comments in particular about the institutions that you're representing, as well as judges who have been the topic of all of panels today. Thank you.
Would you like to start?
Yes, thank you. I would take up the question: what role do national human rights institutions have to engage with the public? And I think Adam Bodnar rightly said we need to make it clear to the public what the rule of law really means, what independence of the judiciary means. And I think we can do that if we, for example, we have to exemplify what the rule of law means. Let us take the corona pandemic that was referred to by a number of authors. Speaking from a German perspective, I would say that what we have seen in the corona pandemic is that independent courts stepped in to protect the population against overbroad governmental regulations, overbroad governmental measures. And that is something that I think was extremely important for my own country, because it then helped us to direct the discussions on what exactly, how do we balance the protection against the corona pandemic with the other rights infringed through measures. So I think that is a clear-cut case to show. And I think that is something we need to do in a better way to make it visible that independence of the judiciary is not something to protect judges for the sake of the judges, but to protect all of us, really. And that is what we need to engage with.
Okay, I think that's a really interesting point you're raising there, because the corona pandemic has changed our perception of so many things, and this is one of them probably. So Adam Bodnar, would you say that in Poland the experience of the corona pandemic and has changed in some respect the perception of this whole independence of the judiciary debate?
I think that it is too early to say it, because for sure there were a number of situations where our rights have been restricted due to pandemic, because the government didn't introduce the extraordinary state, but it restricted different rights via ordinary regulations. But it seems that sooner or later, most of those cases that result from those restrictions will go to court. So for example, right now we observe a series of lawsuits against state treasury for the compensation of damages. And those lawsuits are brought by entrepreneurs. Or we observe that people are protesting against administrative penalties imposed on them, and most of them would most probably go to courts. And I think it is a good opportunity to explain to the general public why independent courts are important in this context. And in my opinion, what is needed, and it seems to me that it is not just a question of Poland, but it seems to me also of other EU member states, is just to spend a lot of time and energy into innovative and creative teaching and education on the value of rule of law and on practical examples why independent courts and rule of law mechanisms are important for every individual. In Poland, we have in this regard quite good examples, and I think the Judicial Association Justitia created a number of interesting ideas, or such initiatives like Free Courts initiative, which used extensively social media to promote the value of independent judiciary. But I think that we shouldn't stop at this. We shouldn't just stop by using this education as just a tool of defending the current situation or defending against those daily attacks and abuses, but we should still continue our effort, and we should still promote our best practices to other EU member states. And obviously, if European Union is interested in investing into that kind of methods of legal education or civic education, I think that should be the role of the EU.
Right. The question that was brought up initially was about not just the courts itself, not just the legal community, but the political public at large. Ms. Adamovich, in your view, would you say that the media and the public commentators in Europe, on the EU level, is doing enough to raise awareness of the rule of law issues that we are facing right now?
Mr. Bodnar already referred wisely to education initiatives, and I cannot really agree more. Education is fundamental. So let me particularly highlight it in this regard, media literacy. We have to teach not only young people, but all the society how to understand the media, not to be manipulated. So, this is, I mean, to support the organization and to support the organization, and the remedy for using freedom of speech to manipulate society is to increase media freedom, independence and pluralism, and big access to information and free journalism. These are the fundamental cornerstones to this issue. So the rule of media, this is really the crucial for us and for education. You must support free media, and we need financing for that. And the other thing is the digital literacy cannot be anymore considered as an additional skill. This is just the skill that everyone needs to have. The modern citizens of European Union, they need to have these skills, and if we will be aware, I think we can defend ourselves from this manipulation, fake news, and not to let be divided.
Thank you very much. Let's hear more from the audience. We think I have another input.
So let me ask two more questions, more specific questions about the reaction to developments that are taking place. So first of all is the development of hate speech, in particular online hate speech, also with regard to minorities. And here the question concerned both the reaction of the states and in particular what Germany in its presidency can take place and whether that is going to be of focus. And the second question concerns reaction to so-called LGBT-free zones in Poland and what the reactions of local communities can be and of national institutions as well, and how any discrimination in those zones can be acted against. Thank you.
Thank you. I think the first question would be to you, Ms. Speck, and the second probably to Adam Bodnar, or whoever wants to comment on that one as well. And I'd ask you to be brief because we have to come to an end.
Yes, thank you very much. I will be very brief, and I would like to thank all the other panelists for making their cases so strong. I think the very good ideas and also support for what I elaborated on at the very beginning, what we plan in our EU Council presidency. We will work very closely with the Commission on the annual rule of law report, and just maybe coming back to the earlier question Ms. Baranowska mentioned, to have a follow-up and really to have a broad discussion. I think that's what the Commission intends, and that's something that will also happen in Germany. National Parliament, the Bundestag, is very interested in the annual rule of law report. And it is an occasion to discuss the report broadly and also focusing on developments all over Europe in each and every member state, not only at EU level, but also at national level, so in the parliaments, in the Länder, but also with civil society. As for your point, Mrs. Adamovich, that you made very strong in the MFF negotiations, I think conditionality rule of law is really a priority for the German government, and we would like to make sure that we really have a strong model established, and we very much support the Commission in its position to have to install a reverse qualified majority to really set the threshold very high. As far as hate speech is concerned and the developments of hate speech and also disinformation, I can confirm that this is also another priority for the German government. We will discuss hate speech in the EU, also focus on developments as far as anti-Semitism is concerned. We would really like to establish a network to exchange information more about developments in several and different member states, and really to create awareness of the developments and trends that we can see. And we could also see during the crisis and as a result of the crisis. As far as disinformation is concerned, just very much the same. We would like to hold a conference to really broadly discuss disinformation, especially in the internet, and also to work on coming up with council conclusions to make a strong case for preventing disinformation, to seeing how the EU, what the EU can do at different levels to protect society from disinformation and to really counter fake news. And I think the past weeks and also during the crisis, we are a very good example and really triggered again how important it is to address this issue. So thank you very much.
Can I only say 2 sentences?
Answer to the second question.
Can I only add 2 sentences?
Of course. Go
yeah.
ahead.
So I would like to point out that the one who is responsible for breaking of rule of law in Poland, this is our governing party. So we cannot really punish the citizens, the social society, because of them. So we have to remember, and when we will take into consideration some mechanism, we have to construct them in that way that we punished the really someone who is responsible for that, because Polish people, they are not really guilty for what the government is doing. Thank you.
Adam,
it seems
the word. It's your turn.
It seems it's now my turn to answer. Yes, Maximilian, am I right? Yeah. So I would like to try to answer those 2 questions concerning fighting hate speech and especially fighting hate speech online. I think there is like one interesting opportunity that comes up during the German presidency, which is the work on the so-called DSA package, which is Digital Services Act package. Why is it so? Because it is this moment when European Union may really do a lot in order to regulate content which is provided on different social platforms and social media networks. And for example, in Poland, we have this problem that there is a discrepancy between provisions concerning protection against hate speech and protection of different discriminated grounds. So, for example, LGBT persons are not protected as such against hate speech, while racial or ethnic minorities or groups or religious communities are protected. And some people are saying that, okay, because there is like this discrepancy, it means that we can do more when it comes to homophobic hate speech. And it seems to me that if the European Union considers inserting all those grounds against hate speech that are included in discrimination, that are not supporting the principle of non-discrimination due to sexual orientation, it is really something important, because it is like this very practical example of combining European values with like real issues of cooperation. Even 2 days ago, I was participating in a webinar organized by the LGBTI interparliamentary group within the European Parliament, and we discussed about this. But I think it's really something precedential, something important, and it seems to me that this letter had an effect on the discourse at the local level. And finally, I would like to say that being the ombudsman, I have this possibility to challenge different local laws to administrative courts. And in the middle of July, will have first hearings before regional administrative courts concerning those resolutions of local governmental units. So let's see what Polish courts will do with those resolutions. I do hope that courts will say that basically they are contrary not only to the EU law, but also to the Polish constitution. And maybe we'll stop the process of adopting new resolutions of that kind, because in my opinion, they are simply shameful and they never should be adopted on the Polish ground. Thank you very much.
Madam Bodnar, Beate Ulrich.
Yes, I simply wanted to take up a question that Dr. Baranowska had reported from the discussions, namely that doubts were expressed whether the independence of the judiciary really is endangered. And to that, my response is clear. The Court of Justice of the European Union, the European Court of Human Rights, the Venice Commission, they all have concluded that there are serious violations of the independence of the judiciary, and they've come to that after close scrutiny. So my assessment, therefore, is, of course, you can disagree with those findings, but if you disagree with the fundamental European values that are at the basis of those findings.
We've come to an end. Thank you very much. I return the floor to our host.
Ja, geben Sie mir noch sozusagen.
Yes, thank you. Please give me the opportunity to share two things with you. The first thing is I would like to express my warmest thanks for your patient listening and watching wherever you were. These were over 3 hours for an online forum. This is really quite a long time. At the same time, we would like to express our thanks to everyone who joined staging this, as those who joined the panel, the discussion as moderators. I think this was very helpful, and it's very valuable that you took the time to do that. And my special thanks, we should not forget that we worked in 3 languages. So thanks to the translators who are with us here in this room, who allowed us to understand each other across borders. In the end, I also want to thank our colleagues from the Office of the Polish Ombudsman, Commissioner for Human Rights, Mr. Bodnar, and also Mr. Taborowski. So we hope for continued good cooperation between our 2 human rights institutions. Also, I want to recall the great commitment in our own, Mrs. Sonnenberg, Mrs. Schäfer, Mr. Stelzer, in our own institute. That is, this team was very committed, and thanks a lot for that. And also Mrs. Young. So my second thought, Mr. Bovenschulte reached out to me. You may recall, actually, our host, who could not participate due to technical issues. And he sent us a video message, which we will upload on the YouTube channel of the German Institute for Human Rights. There you can read what he said. But I'd like to emphasize 4 of his central thoughts, which are very important for him and also for Bremen and our commitment for liberal democracy and the rule of law. The first one is the central importance of rule of law and liberal democracy should always be recalled. Dr. Bovenschulte himself is a lawyer and by training. And he points out how central that is for our own democratic institutions. He pointed, and this is his second thought, he pointed out that some years ago we would not have thought about rule of law as a topic, but that we have to do that now because democracy and political stability have long been seen as inalienable facts, but now have to be defended again. The political tonality changed in this context. The climate has become rougher. Societies too easily drift apart socially and politically. We have to work on that. The third thought is a political counter movement also comes from cities and communities, which send out signals for liberal and democratic developments and can do that. And in this context, he wanted to point out that he sends a very warm virtual greeting from Bremen to Gdansk, because this is one expression of this collaboration. And at the end, he said the liberal constitutional state is so important because fundamental rights and procedural rights are guaranteed, especially also because it guarantees these rights to vulnerable people, for minorities of different religion and different sexual orientation. These are those who really need a state of of law, not just those who are quite well off and moving in the mainstream. I think these are very important thoughts of Mr. Bovenschulte I wanted to share with you. Now, wrapping up, I would like to wish all of you that you continue to have a good day. And we hope that we could send out important signals with this event. We invite you to have another look at it when you can't be with us all the time. It's on the YouTube channel of our institute. You may as well share the stream with colleagues and friends where you think this makes sense, and you may as well listen to the statement of Mr. Bovenschulte. So my warmest thanks for your long attention, and I hereby close the meeting. Thank you.